the enrollment numbers in the ICM have remained flat. And attorneys representing kids report that DOP often tells them the program is full, leaving them without a critical alternative to detention in Horizons or Crossroads. A child can be sentenced to probation supervision or a DOP alternative to placement program. When kids are sentenced to probation, recent statistics show they're less likely to complete their sentence successfully and are more likely to be rearrested or issued a probation violation, an agency failure that shouldn't be put at the feet of children with higher risk and charge characteristics. Enrollment numbers in the DOP ATP programs suggest room for growth to ensure more kids are given a second chance. In all facets of agency operations, DOP must do more to treat the youth incarceration rate with the urgent attention it deserves. Today, I look forward to hearing solutions and not excuses, not just from the Department of Probation, but from ACS, MOCJ, and DYCD. All these agencies have the responsibility to work individually and collaboratively to reduce the youth incarceration rate. I'm also looking forward to hearing testimony on the legislation we are currently considering today, and the two bills that would help shed light on issues that we are here to address. I will now turn it back to Chair Stevens to begin the hearing.
I will turn it over to committee counsel to swear in the administration.
Thank you. With us today from ACS, we have Nancy Ginsberg and Raymond Toomer. From the Department of Probation, we have Joan Gardner and Audrey Wilson. And we also have from DYCD, Daryl Rattry, and from MOCJ, Nora Daniel. If everybody who intends to testify can please raise their right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council member questions? Noting for the record that all witnesses answered affirmatively, you may begin your testimony in whichever order you choose.
Good morning, Chair Stevens, Chair Nurse, and members of the council. I am Joan Gardner, the Deputy Commissioner for Juvenile Operations for the New York City Department of Probation. And accompanying me today is Audrey Wilson, the Director of Special Programs for Juvenile Operations. On behalf of Commissioner Juanita Holmes, I would like to thank you for the opportunity to discuss the DOP's roles with justice-involved youth in New York City. The New York City Department of Probation helps build stronger and safer communities by working with and supervising individuals on probation, fostering positive change in their decision-making and behavior, and expanding opportunities for them to move out of the juvenile and criminal justice systems through education, work readiness, and re-engagement with the community. When a young person becomes involved, justice involved, probation assumes a crucial role in providing information to the court and various stakeholders, enabling them to make informed decisions and appropriate recommendations relating to juvenile matters. Our involvement spans key stages of the juvenile delinquency process, including intake, adjustment, investigation, and community supervision. Furthermore, our extensive partnerships and collaborative efforts across a spectrum of city agencies, diverse service providers, and community-based organizations are essential to ensure the best possible outcomes for young people, their families, and our communities. These alliances, especially amongst our sister agencies, are instrumental in fostering support networks and addressing the multifaceted needs of our young people involved in the juvenile and criminal justice systems. In 2023, the Department of Probation processed 4,743 youths through intake. Probation maintains staffing for detention intake services almost around the clock, 7 days a week for juvenile citywide. This continual process ensures that our youths are not held in detention facilities awaiting court proceedings and are promptly reunited with their families. As a result of this streamlined process, 828 youths, or 17% of our youths, were released from detention following the probation intake process in 2023. Probation also provides intensive community monitoring, which is the ICM program, a program for pre-trial participants who have not been sentenced to probation that aimed at providing participants with intense engagement within the community instead of confinement. Recently, the Department of Probation structured or restructured the administration of ICM cases. When a judge mandates a youth to partake in the ICM program, cases are allocated for more probation officers across the 5 boroughs based on risk assessments. This restructuring aims to optimize our probation officers' capacities and potentially expand our handling of ICM cases moving forward. When a young person's case progresses through family court and receives an adjudication from a family court judge leading to a placement of community supervision, probation officers partner with the youth's family, caregivers, credible messengers, mental health providers, and other stakeholders to effectively engage, hold accountable, and provide opportunities for our youths. Community supervision is provided with the overarching objective of diverting youth from further involvement in the criminal and juvenile justice systems. Moreover, probation administers a continuum of alternative to placement programs designed for high-risk cases necessitating the highest level of supervision, where out-of-home placement would have otherwise been the outcome. Among the ATP programs administered by probation are AIM and ECHOS. Probation also collaborates with ACS in the Juvenile Justice Initiative Program, which is also known as JJI. Through these intensive programs, we partner with community-based organizations and strive to promote a well-being and a resiliency of our youths. Our focus is on guiding them towards positive behavioral transformation and establishing sustaining connections within community networks. Probation views the adjudication of a youth as a pivotal moment for redirection, emphasizing both accountability and the chance for positive change. The city remains focused on preventing youths from entering the juvenile and criminal justice systems altogether. Through initiatives like NEONs and community programming, probation facilitates networking and engagement within local neighborhoods, fostering connections, encouraging behavioral transformation, promoting educational attainment, and creating avenues that deter youths from involvement in the juvenile and criminal justice systems. Our newly launched program Locator, accessible via our probation website, enables our clients and community members to easily find programs and resources within their neighborhood or vicinity. With a simple click, DOP's program Locator provides individuals across the city with access to a wealth of opportunities. By tailoring programs or programming to the interests of our city youths, probation not only establishes connections, but also keeps them actively engaged in constructive activities. I would now like to turn to the 2 bills being heard today. Both Intro 87 imposes a new reporting requirement on DOP relating to individuals' process through the family court. Intro 977 would expand DOP's reporting requirements on the Local Law 90 to a biannual report that also includes data on violations of probation filed. DOP is willing to be transparent. However, the frequency of the reporting requirements would present operational and staffing challenges. The administration supports the intent of the bills and look forward to working with council and the bill sponsors on the most effective way to achieve the goals of the bills. The Department of Probation remains steadfast in the commitment to providing comprehensive support and guidance to the youths of our city. Through innovative programming, community engagement, and a dedication to rehabilitation, we strive to create pathways towards success while prioritizing the safety and well-being of both our youths and our communities. I'd like to thank you for the opportunity to testify today and for your continued support. I am pleased to answer any questions you may have.
Good morning. My name is Nancy Ginsburg. I'm the Deputy Commissioner of the Division of Youth and Family Justice at the Administration for Children's Services. I am joined by Raymond Toomer, the Associate Commissioner for Community-Based Alternatives, as well as my colleagues from DOP, MOCJ, and DOICD. We would like to thank Chair Stevens, Chair Nurse, and the members of the Children and Youth and Criminal Justice Committees for holding today's hearing and providing us all with the opportunity to share collective efforts to help youth reach their fullest potential. We appreciate your interest in ensuring the city has the services, supports, and interventions needed to prevent as many youth as possible from being detained. We are pleased to testify today on our efforts to provide these services as upstream as possible so that we can build a New York City that is more just, safe, and equitable for youth, families, and all New Yorkers. ACS administers a range of programs to prevent and reduce youth incarceration. The Family Assessment Program, or FAP, is a voluntary program that provides a range of community-based supports such as crisis mediation, mentoring, respite, family therapy, and intensive evidence-based programs. FAP helps parents and youth build skills to address intrafamilial conflict and connects them to services which address running away, substance misuse, and truancy. In 2023, FAP's providers served nearly 2,800 families citywide with interventions including family stabilization, functional family therapy, multi-systemic therapy, brief strategic family therapy, respite, and a mentoring and advocacy program that recently incorporated the Fair Futures coaching model. Since July 2023, ACS has been administering the Alternatives to Detention programs in family court for youth who are at risk of being detained. The ATD providers, Cases in Manhattan and the Bronx, Good Shepherd Services in Brooklyn, and the Center for Justice Innovation in Queens and Staten Island promote positive behaviors, healthy relationships, and problem-solving skills. The model includes curfew checks and individualized supervision and services during the pendency of the juvenile delinquency case, with the goal of improving court appearance rates and preventing rearrest. In addition, youth are connected to vocational, educational, and social programming that is tailored to their specific needs. These services reduce the number of young people entering detention and provide young people with the skills they need to thrive in their communities, thereby contributing to long-term public safety. ACS also oversees the Juvenile Justice Initiative, or JJI, an alternative to placement program in family court, diverting young people from being placed in close to home. JJI is ordered by the court as an additional support to a probationary sentence and provides intensive, home-based, evidence-based interventions, multi-systemic therapy or functional family therapy, and services to adjudicated youth and their families. While ACS's services have historically focused on youth with cases in family court, we are piloting an initiative with Cases to provide alternative to incarceration services in the youth parts for young people whose cases remain in the adult court system. In addition to the traditional ATI services available through Cases, the pilot offers an in-home therapy component. ACS administers 2 secure detention facilities, Crossroads and Horizon, which house young people who are ordered by a court to be held during the pendency of their case in Supreme or Family Court. ACS is not a party to the cases in either court and has no role in the judge's detention determination. The population of youth detained in Crossroads and Horizon, similar to other juvenile detention sites across the country, has increased from the low numbers reached during COVID-19. Although the population has increased since 2020, the overall number of young people detained in New York City is still lower than it has been historically. The current population of 16 and 17-year-old youth in detention is half of what it was in 2016 and 1/3 of what it was in 2013. In January 2013, there were over 300 16 and 17-year-olds held on Rikers Island. In 2016, there were 200, and in 2018, there were 125. Now there are about 100 16 and 17-year-olds in custody, with the remaining youth in detention being between the ages of 18 and 20. Although the historical population number has been reduced, the detention centers are holding older youth who remain in custody for a much longer time on more serious charges. Youth are primarily in detention pre-trial, and we are seeing increased lengths of stay due to the fact that the youth have complex, serious cases that take a long time to move through the court process. About 70% of the youth in detention are there due to a murder or a murder-related charge. Moreover, secure detention no longer holds youth charged with minor charges. About half the youth in secure detention are between 18 and 20. New York City's juvenile detention population is proportionally smaller than other large cities. New York City is 3 times larger than Chicago, which has more than 60% of New York City's secure census. Philadelphia is 5 times smaller than New York City, with almost the same number of youth in detention. ACS is engaged with DDC in a process to build additional program and housing at Horizon to better meet the needs of an older population experiencing extended stays in detention on very serious alleged offenses. This space is being intentionally designed with therapeutic and supportive lens and will enhance our ability to provide safe and quality care to young people with expanded academic and vocational classrooms and increased medical and mental health capacity. We appreciate concerns associated with building new capacity and want to assure the council that we will always do all we can to reduce the number of youth coming to detention while providing the youth in our care with the highest quality service we can provide. As to Intro 87, ACS appreciates the council's interest in data related to young people in detention. We look forward to discussing this bill, which amends the requirements of our current juvenile justice quarterly and annual reports. Thank you for the opportunity to testify before you today, and I am happy to answer any questions you may have.
Thank you for your testimony. Just a quick housekeeping. We know it's a little bit tight in here, so if folks, they will have the hearing in the chambers if folks want to go and listen there if it becomes too tight. So just so you know, we have an overflow room if folks want to stretch their legs and go into the chambers as well. And I will turn it over to Councilmember Nurse to start us off with questions.
Thank you, Chair Stevens. I'm going to start off with questions for Department of Probation. I have a few kind of baseline questions just to get on the record some information about where we currently are. So I'm going to start with ICM. For anyone who doesn't know, it's a family court and youth part pretrial program designed to supervise participants while they remain in the community throughout the pendency of their case. So I have a handful of questions around this program. What is ICM's maximum capacity? How is the program's capacity determined? What is the price per participant in the program? And how many probation officers are currently assigned to work on the ICM programs?
Thank you for that question, Chair Nurse. So when we originally managed the program, there are 90 cases that we could, assume in the program. There are 20 each per borrower, except for 10 in Staten Island, as per verbal agreement born out of Raise the Age. Since that time, we have redesigned the program. We have currently redesigned the program working, because before the program was working in silos. So we redesigned the program, now allowing the possibility of expanding our capacity to take on more cases, and we have not turned any clients away. Right now we have about 39 probation officers assigned to take on ICM cases citywide. And so it enables us to expand the program and accept as many cases as possible. So there's no limit, no capacity at this time.
You're saying there's no maximum capacity for this program?
No maximum capacity at this time, correct.
Okay, so I'm sorry, you're saying originally the program was designed for 90 folks, now you've redesigned it, and it's limitless. You can place people all throughout this.
And I'm sorry, can you give a little bit more detail when you say redesign? Because I don't, and just so we can have on record, what are the improvements that you did other than the expansion of the officers? What does this redesign actually entail?
Well, The program worked in silos before. There was an ICM unit. What we did was we moved ICM cases, they're citywide, so every probation officer can manage by risk, and they are qualified and capable of assuming a ICM case. So every single probation officer, because we manage by risk, can take on an ICM case.
Okay, did you answer the question of what's the price per participant?
Okay, so the price for participant, we don't break down the price per participant, but our city budget is $816,000 for citywide year 2024.
And did you say how many, what's the caseload per officer?
Currently, officers can have upwards of 50 cases for a hybrid caseload. However, our ICM numbers are pretty low in comparison to an average caseload.
So they're currently holding 50, but you're saying?
Up to.
Up to.
Upwards of
And so
50.
what are they holding right now on average? Do you know?
An average of 20 to 25
20
cases.
to 25?
And just as you were talking and saying, like, you guys are redesigning the program, what did the support for the PO office look like? Was there trainings? How are you supporting them? And also, up to 50 cases is a lot for anyone to take on. So what was the rationale behind increasing a caseload to that capacity?
Before, we only had 2 ICM POs assigned per borough, and the officers were working in silo, and the borough, they were working in silo. Now that we expanded ICM through the 5 boroughs, now officers can take on more cases, and they don't have to be ICM officers because all officers are trained to manage based on risk. So all supervision officers can take on an ICM case because we manage by risk.
Okay, but again, what was the training look like? How did you prepare the officers to expand and do this work? If it was specific officers before designated for it, how did you get all of your PO officers up to par to be able to do this work? What did that look like?
So the cases are assigned to high-risk officers, and these high-risk officers have already received the training. They're supervising high-risk cases. Those are cases that were formerly placement-bound. So they can take on and monitor a high-risk ICM case because they have the qualifications and they have the experience and the training to do so.
And before Standing Nurse, Councilmember Nurse takes over, I just want to acknowledge Councilmember Caban, Councilmember Ressler, Councilmember Aviles, and Councilmember Mena who have joined us, and Councilmember Abreu.
Okay, so according to DOP data, ICM served 394 youth in 2023. At the executive budget hearing earlier this year, Commissioner Holmes said that ICM was now prepared to accept all court referrals, and you referenced this in your opening statement. What we've heard from defense attorneys that ICM remains full in the Bronx and that there have been periodic capacity issues in Brooklyn as well. So why is this message being conveyed if there is now no limit?
The ICM capacity prior to the expansion was 20 cases per borough because ICM has upwards of a 60-day maximum period, 120 days in family court. When we expanded and redesigned the program, it now enables us to increase our capacity by accepting as many cases as needed for high-risk monitoring as possible. So before, they were working in silos, and they were only able to manage 20 cases.
I understand what you're saying, but what I'm trying to understand is you're saying this is a limitless program. You have absolute capacity. The commissioner testified the last time she sat before us that anybody who needed a referral could get it.
That's
and
correct.
What we're hearing from on the ground is that the people who are actually doing this work are saying, actually, that's not true. They're having cases not be referred. So, for example, today, right now, in the Bronx, are there open slots available?
Yes, there is. In the Bronx, we only have 8 ICM cases assigned.
That's your testimony today.
Yes.
Okay. So why, why are the numbers so low? Because it would seem like there would be, if there's capacity in the system, you have open slots, why are the numbers so low for the referrals?
ICM is a court-mandated program, so probation is not a party to that decision. That decision is solely based on the court's decision, mandate. So it's predisposition. It's a predisposition program, and the judges are aware of the ICM program, and we're not limiting capacity. So any young person that is high risk or medium risk that needs the ICM service during predisposition, they're suitable for the program. We're not turning anyone away.
Okay. Well, I'm sure we'll hear testimony from providers who have let us know that their cases aren't getting referred, so we'll check back up on this in future hearings.
Thank you, Counsel.
What are the time limits on how long a young person can be in the ICM program?
The ICM program is designed for a 60-day maximum period.
And do cases generally get resolved in this period?
Most of the time they do, and so we want to stick to the 60-day maximum period because that allows us to extend the ICM program to other young people in need of the services.
Okay, so what happens if a case is still pending when the defendant has reached the ICM limit?
We generally notify the court that the case has reached its maximum capacity. Again, that's a judge's decision whether to continue, but we are notifying the court when the case has reached maximum capacity, maximum limit.
Yeah, how often are cases reaching that limit or going past the 60 days?
Unfortunately, I don't have that data, but I can get back to counsel.
Okay. We'd love to have that in the follow-up, just to get an understanding of if the rationale for the 60 days is holding up based on what the numbers are showing. Okay. Is there any particular reason for the 60 days for the ICM program?
That was a verbal agreement that occurred when the ICM program was first initiated. I know in October of 2018, because of Raise the Age, ICM was revamped, and the capacity at that time was 20, and the verbal agreement was 60 days for family court and 120 days for youth part.
So in 2023, how many young people qualified for alternative detention but were put in detention because there was no available slot at a DOP, ACS, or MOCJ ATD program?
For probation, the alternative detention program that we have is the ICM program.
And your testimony today has been there are no folks who are being referred that are not receiving slots in your program.
That is correct.
Okay. For AIM, a court-mandated 6 to 9 month ATP program for youth ages 13 to 18 who are under DOP supervision, what is AIM's program maximum capacity?
Thank you for that question, Councilwoman Nurse. So AIM's capacity is 76.
And how is the program's capacity determined?
That determination was made during the agreement that occurred many years ago. The capacity, I can defer to Senior Director Wilson, who can shed some light on the history of the AIM program.
Good morning. The 76 was determined based on the number of young people that were going into placement back when the AIM program was implemented. It's broken down by borough with 20 slots going to Brooklyn and the Bronx, 16 for Queens, 10 for Manhattan, and 16 for Queens, 10 for Manhattan, and 10 for Staten Island.
Okay. And so what is the price per participant?
Right now, it's budgeted for approximately $4 million. There is no specific price.
And do you all have you done any periodic assessment of whether or not this capacity should increase or not?
Thank you for that question, Councilwoman Nurse. Because the AIM program is underutilized, it's a robust program, and we can take on additional young people in the program. Right now, we are focused on AIM, and we are getting the message out to the court that the program is up and running, it's robust, it works, and so we want to maintain and increase the capacity by our messaging to the court.
So the capacity is 76. What is the current participation rate? Or how many people are currently in the program?
Okay. For the AIM program, we have approximately 12 youths that are in the program for 2024. Last year, 2023, citywide year 2023, we had 19 youths.
Okay. Do we have an analysis, or do you have an analysis of why there are so low participation numbers for a program that can hold 76 people?
Again, Councilwoman Nurse, as I mentioned, these are court-mandated programs. The judges are well-versed on the programs, and so the messaging will continue to be, we are open, we're ready, we have the capacity, we have 76 slots, and we need young people to be a part of this programming.
I'm just a little concerned because there seems to be a major disconnect of the numbers that you guys are saying when we're speaking to defense attorneys around the work, and even just saying like the judges are aware. How are you ensuring that the judges are aware of these programs, that you're open and you're ready? Because what we're hearing, seeing, and what's happening is not what's going on. So I'm really concerned about, it's just like, oh, they know and this is what's happening, but that's not what we're hearing. There seems to be a discrepancy. So I need you guys to just kind of give us a little bit more information about what does that outreach look like? How are you determining that the judges know about this? How are you determining that this is part of the negotiations? What does that look like? Because the numbers are just too low to say like, oh, well, people know. Maybe they don't.
I understand your concern, Councilwoman Stevens. So every month, on a monthly basis, our local bar directors are having meetings with the judges, the delinquency judges and the administrative judges. We also provided our court liaison officers with packets that can be disseminated to new judges. But what I also stress coming on board to the managers is that you must also meet with the new judges, share the packets with them, have those lunchtime meetings with them to tell them about all the programming. So we're engaging in a rigorous messaging with our courts, with our judges.
And also even thinking about, yes, I think the judges are a huge part of it, but how are you working to ensure that the lawyers are also on the same page about programs? Because that's one of the things that especially the defense attorneys have been saying is they don't know or are aware of some of these programs to even bring it up during these cases. So what does that piece look like? Because this is not making sense that we have these programs that have proven track records and the numbers are consistently low, and we're doing the same outreach and not getting the results that we want. So that doesn't make sense, especially you're saying like now we only have 12 people in the program and our numbers in the detention centers are continuously rising. So for me, the sense of urgency, I'm not feeling it in this moment.
I share your concern, I share your concern, Councilwoman Stevens. In addition to the monthly meetings, or along with the monthly meetings, all agency heads are at these meetings, these local agency head meetings. So all of Defense Counsel, Legal Aid, the Law Department, all agency heads are meeting locally at these meetings. So the message is getting out. However, how it's disseminated from there, we'll have to take a look at that. But we are meeting with the local agency heads for all departments and stakeholders on a monthly basis.
Yeah, there's a glitch in the matrix, but I'm going to pass it back over to Councilmember Nurse to finish these questions.
Okay. According to the mayor's management report, there were 87 new enrollments of young people in ATP programs in FY 2023 versus 94 in FY 2022. The report stated that the decline in enrollment was the result of a loss of a contract program provider. Can you tell us a little bit more about which DOP ATP program lost a provider? This was from the mayor's manager report when it was describing the decline or the decrease in enrollment. It was saying that there was a loss of a contracted program provider.
Is this a DOP program that you're referring to?
In ATP programs, yes, DOP ATP.
Juvenile Operations has not lost any ATD program contracts.
Okay, we can look back at that. ECHOS is an ATP program that offers conflict management, job training, and life coaching services to justice-involved youth ages 14 and older. Since 2017, participation in the program has been relatively low, never reaching above 36 participants. In 2023, despite receiving $900,000, a little over $900,000 in funding, the program reached an all-time low of 12 participants. What is the capacity of the ECHOS program? What is the budget, and why do you believe that enrollment is so low?
Thank you for that question, Councilwoman Nurse. So ECHO's capacity right now is 30. We have 30 slots. Again, this is a court-mandated program. And again, we are speaking to the judges, we're speaking to the agency heads about our programming. We're preparing packets for the CLOs to distribute. So, you know, I share your concerns because the message is getting out to the stakeholders and to the judges, because we're open and we're ready and we know that ECHOS works, just as we mentioned that AIMS, you know, the AIM program also works. So the overall budget for the program is $871,801. We don't necessarily price it out per participant, but if we did 30 divided into 871, that would be about $29,060.
Okay, I'm going to move on. The increase in detention admissions coincides with cuts to a range of prevention and early intervention services for young people like Next Steps and Arches. We spoke about Next Step and Arches extensively in our budget hearings. And these are programs designed to help young people avoid arrest and recidivism. Do you see a link between these cuts and an increase in youth detention?
Thank you for that question. However, I'm not the subject matter expert on the impact and the steps, the Next Step program and the impact program. My commissioner spoke about the program, the different situations that were going on with the impact program and the Next Step program. The Next Step program was a community-based program, which is no different from our Arches program, which has expanded to include not only DOP clients, but also community members, including those in NYCHA. Therefore, there is no one that's left behind, really. And the impact program, we have other programs such as the mobile adolescent portable therapy that support and serves the needs of the.
You're saying you're talking to these judges, you're allegedly doing outreach, but we have programs that were on the dock that had people in it that were just as low as the numbers we have now. I think at the last hearing, the commissioner testified, she cut the program because it was about 20 participants. It seems like you've had that as an average for most of your programs at this point. So it's not clear why there was a rationale to cut them, and it's unclear to me what the plan is to compensate for the loss of these programs. So what are the plans to scale up? What are the plans to get these programs in place, get them filled, and actually keep people from going into detention facilities?
Okay. So again, Councilwoman Nurse, I'm not the subject matter expert for the impact and the Next Step programs.
I wasn't talking about impact. I said Next Step and Arches.
The Next Step program and the Arches program.
Okay, so I just want to understand, if your title is Head of Juvenile Operations, and I'm really not trying to be nasty, but I'm just trying to understand what is the subject expertise matter that you would have if not these programs?
Thank you for that question. So probation runs the AIM program and the ECHOS program and the ICM programs.
Those are your programs?
For juvenile operations, correct.
Okay. Thank you for that clarification. I'm going to go on to impact because we've talked about it quite a bit. It was terminated in July of 2023. According to the program's RFP, it would have provided home-based family therapy and credible messenger mentorship to adolescents between 12 and 18 with an old case pending in court. the reason we were harping on this program so much is because of the number of slots this program was going to provide. Because everything here is 76. Everything was much smaller. At the last hearing, the commissioner testified that the program that was adequate for it as a replacement only had about slots for about 36 people. So we were talking about why would we be preventing a program from starting that had such a large capacity given the amount of people going into detention. And we haven't heard what alternatives are available at that scale for young people who would have been served by impact. So do you have any anything you want to share with us today about what alternative programs would be available?
I'm going to defer to Senior Director Audrey Wilson for Special Programs and Juvenile Operations.
So the impact program was due to serve in a different jurisdiction, which was going to go into the Supreme Court, ages 16 to 24. It was not a juvenile program. However, we do have abundance of services that we do introduce to the young people that are within our jurisdiction.
Can you explain those services?
I'm so sorry. Can you repeat that for me, please?
You said you have an abundance of services. I would love to hear what this abundance of services are.
So we have work readiness programs that we work. We have a PEAK program that offers work readiness to young people that are currently on our caseloads. It's a phase.
How many people are in that program? What's the capacity?
30. The capacity is 60, 30 per site, and we have approximately 37 in PEAK at this time.
I'm sorry, repeat the name of that program again? I missed
PEAK
it.
program, Pathways to Education and Knowledge.
Okay.
On the program, because I know you said it was an abundance.
We also have the Adolescent Portable Therapy Program that DC
There's
Garner just
36.
spoke.
36
Yes,
kids,
and that is in-home therapy, which is similar to what the services that Impact was going to perform. We currently have 13 youth in that program. There is space.
13
Yes,
currently
and
in that program.
yes, and we have space to accommodate more.
Its capacity is 36.
I'm so sorry
The
that,
capacity for that program, 36?
yes.
Oh, my mic is
Well,
not on, I'm sorry.
I'm sorry, it is 12 at one time, but up to 36 a year.
It's up to
yes.
36. And so, just so we know, the numbers that we're at is still under the amount that this, that Impact would have served, which was at 175. So, I know you said there was an abundance of programs, so I guess let's keep going.
And I just wanted to say that in the event that we reach capacity, we have the ability to expand. We have not reached the capacity in our current programs, so we haven't had the need to expand, but we have spoken to the providers, and if need be, we can increase capacity if needed.
Okay, I know you said on those abundance, are those only 2 programs?
Actually, we also have AIM Light, which is a modification of the AIM program. We understand that AIM has been a tremendous support to young people in the community. So young people who were not disposed of at disposition in AIM program still get to avail themselves of that program. They're matched with a credible messenger, an advocate in the community that can work with them and provide similar services as if they were in the AIM program.
What's the capacity for that?
That is, we don't have a limit. Right now, we have
How many people are currently enrolled?
approximately,
And you would have already had to be in AIM to be,
no, you do not.
Okay.
If you're a young person that are in need of a mentor or maybe experience challenges on your current level of supervision, we will match you to a mentor to kind of help you overcome those challenges.
how many young people are in this program?
I would, year to date, we have served 75.
75. So 75 people are currently, or you've served up to 75?
31 are currently in,
31,
and year to
okay.
date, there have been 75 young people.
And I know you said it was an abundance, so I think we would keep going. I would love to hear the abundance, because that was aggressive.
Maybe I should say that we have an abundance of
A few
capacity.
programs. We have a
Yes.
few programs.
There were
I'm
fruit
sorry.
programs with
Few programs that
less
don't.
than 100 people in it.
Less than 175, and the rationale continues to be that, that the APT program is a replacement, is suitable, that all of these other ones are suitable, and it still seems, I think at the core of it, whether it's Impact or any other program, it still seems to be about scale for me, because it seems like we're not hitting the scale of participants that would actually start to make some dents in some of these numbers. And we had something on the docket, and for whatever reason, we still can't seem to get like a real rationale for why this never took off. It seems like the provider that was ready to do it is still ready to do it, and you all have decided we don't want to do this program, but we're going to do these smaller programs, which is fine, as we should have as many programs as possible going. So we're not saying an abundance of programs. So it just feels baffling to me why we're not fully employing all the tools that we should be utilizing to hit the scale of slots that we need. Okay, so according to the mayor's management report, the juvenile intake adjustment eligibility rate decreased 18 percentage points during the first 4 months of fiscal 2024. This trend was driven by an increase in the number of juveniles with felony charges that were referred to probation, which was beyond the agency's control as it is at the discretion of the court system. In your view, what is leading to the decline in case adjustments?
Thank you for that question. We are guided or informed by the statute, which is Family Court Act 308.1 and the Uniform Rules of Family Court 205-22, which determines how a case is deemed suitable. And suitability is actually based on the statute. We look at the youth's legal history. We also look at the nature of the offense, and we're guided by that under some enumerated factors in the Family Court Act, which specifically provides the offenses that cannot be considered for diversion, such as reckless endangerment, manslaughter, criminal possession of a weapon, first degree. And so, guided by the statute, we divert based on the statute. In terms of determining suitability, we're guided and informed by the statute. So we may be seeing some more egregious offenses that the statute disqualifies them from diversion consideration.
Okay, we did have some questions about what are the factors for DOP's assessments. We did get those last night, I believe, although we asked for them about a week ago. So we haven't even had time to look at them, but so if you could state for the record, what are the factors that DOP uses to assess a case, and specifically in what circumstances does DOP not have the authority to recommend adjustment?
Thank you for that question. So DOP cannot divert cases that are deemed to be designated felonies. And so those designated felonies are enumerated in the statute. And I mentioned reckless endangerment, for example, burglary, manslaughter, second degree, rape, third degree, sodomy, third degree, criminal possession of a weapon, sexual abuse, first degree, criminal possession of a weapon, first degree, coercion, first degree. Those offenses are designated felonies, and they can only be diverted by the court.
But you all can recommend a diversion, right?
No. So when we divert a case, we divert a case. When we refer the case to the law department, we do not make recommendations to the court.
You do not make a recommendation if just to restate what you're saying, you will not make a recommendation if you cannot convert the case.
When we refer the case to the law department conducts an investigation to determine whether or not the case should move forward to the court process. Probation is not involved in that decision making. Probation is not a party to that, decision making, or even in court.
Okay, just according to the Family Court Act, DOP has the authority to recommend adjustment in every case. However, as you're saying, there are certain felony cases where the judge or the corporation counsel must consent for adjustment to actually occur. So you're saying that you do not have the authority to make a recommendation on every case?
Again, probation, when the case is referred to the law department, it's referred to the law department for an investigation. Probation is not a party to that discussion with the law department, and if the decision is made to file a petition on the case, probation is not a party to that discussion.
Okay, just a few more questions on adjustment. When DOP reviews complaints, are there specific charges for which DOP will never, next question. Are there written policies or procedures provided to probation officers who make the determination whether to recommend a case for adjustment? Have there been any written directives issued related to the adjustment process issued since the beginning of 2022?
No, there has not been.
Okay, I think those are my questions for adjustments. Do you have any?
No, I was, we're not done with DOP. We're gonna give you a little break, drink some water. We're gonna come back to y'all. We're gonna move over to ECS. So, the Juvenile Justice Initiative, JJI, is ACS's ATP program that is available in all 5 boroughs. JJI allows young people ages 12 to 15 who have been found to be juvenile delinquents in family court to remain at home where they receive intensive services. How much funding did the JJI initiative receive in FY 22, 23, and 24? How many young people were served by the program in those years? What is the funding per participant? And JJI services are available for young people who have a willing caretaker to participate in the services. Are foster care youth eligible for JJI? And if not, if they do not have a caretaker? That was a lot of questions. So any of them that you need me to repeat, I will.
No, thank you for that question, Chair Stevens. First, a bit of clarification. JJI is available for youth up to age 18, so your question referenced youth up to age 15. In FY
For that correction.
In FY 22, we served 151 youth through JJI. FY 23, we served 149 youth. And so far this year, we have served 143 youth through June 20th. We have allocated $11.2 million per year for JJI.
11 what?
11.2. And I forgot your other question. It was cost per slot, so we'd have to break.
First part participant, yeah.
Yeah. So I don't necessarily have a
Okay, you could give them to us.
Oh, I do.
Oh, she said you got it.
It is about $48,000 per participant.
Okay, and then the last question was just around the eligibility for foster care youth because it's such an intensive program with a caretaker. So what does that look like? Does this mean that if you're a foster care youth, they're not eligible? Just trying to get more information around that.
Youth in foster care are eligible as long as they have an adjudicated case in family court. It is a mandated program. So as long as they go through to disposition, we are able to provide JJI services if the court.
How often does that happen? Because it seems like it would be a burden on a foster care parent. And is that something they can be like, well, this is something that I don't want to participate in, and there's a lot of follow-up. So what does that process look like?
Right. So JJI is a condition of probation. So a young person or family could determine that they're not interested in participating, and the judge then needs to make a decision about whether they're going to place that youth or allow that youth to remain in the community. I don't have exact numbers on the number of foster care youth who are involved in JJI, but being a foster care youth does not preclude them from.
Yeah, I know it wouldn't preclude it, but I'm just, and this is something we can definitely have a follow-up conversation about, like what does this really look like? And are young people who maybe in foster care have a higher risk of not being able to get offered this or go to this because a foster care parent is like, no, I don't want to do this.
So JJI has a suite of services, and one of those services is multi-systemic therapy and adaptation for emerging adults. And that particular intervention does not require the caregiver's involvement. And so youth up to age 21, particularly for youth who are couch surfing, they're mobile, they're not in a particular stable environment, that is the service that we would recommend for
Okay.
that young person who doesn't necessarily have a stable caregiver. I think one of the things that's unique about JJI is that we do try and tailor our services to the unique needs of youth. We have 4 adaptations of MST, and so we try and make the best fit after assessing what's appropriate.
That's good to know, and the flexibility is also really important. Okay, at the ACS executive budget hearing, the commissioner testified that the agency is developing an ADT pilot program to serve older youth with cases in the youth part of Supreme Court. Please expand on the services that this pilot will provide.
So this is a recently started pilot. Cases is the agency who's providing these services in the Bronx and Manhattan. It's our first foray into the youth part, as you mentioned. We just started about 2 months ago, and they're using their APT, which I forget the acronym. So they're using APT, which is an in-home therapy. They've been going through the process of hiring a therapist. They just received their first 2 referrals last month, and there is 1 youth engaged in the program right now. We were hoping that they could get between 10 and 15 youth in this fiscal year, but they're still marketing the program and engaging judges in the youth part.
How many providers will ACS contract for this program, and what will be the total number of slots?
So it's just a pilot program right now, and we just have the 1 provider.
It's going to be the one for now.
Correct, yes.
Okay. And what does the assessment look like? Because I feel like we do a lot of pilot programs in the city, and then we'll be like, all right, next week, we're just going full scale. So, and that's probably one of my biggest pet peeves. So in this pilot, what does that look like to assess if it makes sense to develop it into a full throttle program, and what are the indicators for those things?
Yeah, so I mean, I think the biggest indicator is whether they get the referrals, whether the stakeholders are interested in the program and they feel that it's filling a gap. And so we will continue to work with cases and family court and youth part stakeholders to determine whether
and this is why it drives me crazy, because even in the start of the pilot, were there specific goals and targets that you were trying to reach that you're using this pilot to drive that data, or because again, I feel like I'll come in, we'll talk here now, and the next year you're like, yeah, we're rolling this out, and I'm like, okay, well, what were we looking for? And
Right.
I don't want to do that.
So
So if you didn't do that, I would love for us to figure that out.
Right. Well, I mean, like I said, the biggest thing for us is referrals and whether it will demonstrate whether this program is necessary and needed in the youth part. And then,
And what
of course,
else other than referrals?
I'm sorry. With all of our programs, though, we do look at levels of engagement, how many contacts were made, what the outcome of the young person's case was, whether they completed the program successfully, all of those things. And then ultimately, whether they were rearrested and made all of their subsequent court dates, right? Those are
Then
things.
why aren't those things part of the pilot to quantify? So we'll talk offline, because I don't want to put a bill in this, because I feel like we always do these pilots, and then it's just like, the things that we're looking for, so why aren't we specifically honing in on them, so that when we come to the end, it can be like, we met these goals, this makes sense, this is working, this isn't working. But we'll talk offline about it. I'll let it go. So you said the pilot already has launched. Okay, great. The Center for Alternative Sentencing and Employment Cases in the ADT reports that the Manhattan location has served no more than 10 youth at a time. What does ACS believe the reason for this underutilization?
That for the Alternative to Detention program? So from our perspective, our Alternative to Detention programs in what are our 3 high volume boroughs have been almost overutilized in Queens, the Bronx, and in Brooklyn. In Manhattan and Staten Island, we just aren't seeing as many referrals. Those programs, as we've stated, are mandated by the court. And so we just aren't seeing the numbers of referrals coming in from Manhattan and Staten Island. But our ATD programs citywide this year have served 279 youth. We've closed out 198 cases. 75% of those cases were closed successfully. And when you mention outcomes and metrics and some of the things that we look at, a successful case closure is one in which a young person did not suffer a rearrest. They completed the program, they got to disposition on their case, and they were usually enter regular probation situation.
Last March, an announcement was made that ADT programs previously managed by MOCJ would transition to be overseen by ACS. How many young people currently enrolled in each ACS ATD program?
So we have 81 youth in our ATD programs currently. There are 23 in the Bronx, 10 in Manhattan, 26 in Queens, 1 in Staten Island, and 21 in Brooklyn.
Of the youth currently enrolled in the ACS ATI program, how many young people are considered low, medium, high risk, or reoffenders based on the detention risk?
Right. So of the 81 youth that we had as of May 31st, 2024, I should clarify that, there were 49 of those 81 were medium risk, that's 60%. 16 were identified as high risk, that's 20%, and another 16 were identified as low risk, so that is also 20%. So 60% or the majority of our young people are medium risk young people.
Assessment administered by DOP. Okay. The current program targets youth who score medium risk on the detention risk assessment instrument. Does ACS have any plans to expand program capacity to serve more high-risk youth?
So at this time, we don't have plans to serve more youth. You know, we assess each youth that comes our way. Like I said, ATD programs were meant to be for medium risk youth. Our thinking is that low risk youth should be released into the community.
Yes, we all agree on that.
And high risk youth should probably get more attention than our ATD programs can provide. But we have not had to turn away young people from our ATD programs. So although, you know, we'd like for capacity to be at 25 at the most, I just mentioned that our Queens program is at 26. And so they will take on additional young people if those young people are referred to us.
ACS has previously indicated that ADT program could consider allowing referrals directly from Youth Part on a case-by-case basis. Since the program began, how many enrollments have come from direct referrals from the Youth Part? Under what circumstances is that permitted?
So we do not take ATD referrals from the Youth Part. We have our pilot in the Youth Part, and that is our only involvement.
So it's just the pilot currently?
Correct.
Okay.
Our ATD programs are all in family court cases.
Okay, so I'm gonna pause there with ACS. I'm gonna ask a few questions to MOCJ, and then I'm gonna go to DYCD, and then I'll open it up to colleagues. I have a couple more questions for you guys too, but I know my colleagues, they wanna ask some questions. Welcome to the party. No, there was one at the beginning. In 2018, MOCJ testified that the city council that supervised release was key to keeping young people in the community, ensuring successful implementation of Raise the Age. Please share a breakdown of how many people under 18 years old were on supervised release from 2018 to 2023, and currently how many people under the age of 18 years old are enrolled in MOCJ's supervised release program, and are all those enrolled for young people with the case pending in the Youth Part? And I can repeat any question you need.
Multi-part question, so I'll start at the beginning. So since 2018, year over year, there started out with about 200 kids people under the age of 18 in supervised release in 2018, and in 2024, it's 235. I can get that for you year by year as well.
Okay. Currently, how many people under 18 years old enrolled in the MOCJ Supervised? Is that the 200 or?
It's 235, yeah.
235, okay. According to MOCJ website, MOCJ is funding 24 ATI programs run by 14 nonprofits. However, this information, which was last updated in 2022, appears to be out of date with the current mayoral administration policies. Is this information still accurate?
It's still accurate, yes.
It's still accurate? And so none of those things have changed since 2022?
No.
Okay. How many, wait, hold on. How many young people under 18 are enrolled in the MOCJ-funded ATD and ATP program?
So those programs have all transferred over to ACS.
All of those, so those, okay. Does MOCJ have any plans to expand its capacity to serve more young people with cases in the youth part?
So we are, our ATI programs currently do serve young people in the youth part, and we're constantly assessing whether or not, what those needs are, and whether or not they need to expand.
What does those
Currently-
assessments look like?
So we look at our data, see how many youth are coming into ATI programs, and we talk to providers about what's needed, providers and other court parties about what's needed. So that's what the assessment looks like.
And so where are you at with the assessments?
So we're constantly looking at the data to see how many youth are coming in and whether or not that it's meeting the demand that we have. And so far, it does appear to be meeting the demand.
I like the word appear. We've heard from legal providers that when a young person are in is part of the ATI program while their case is being heard in the youth part, they lose access to programs that help provide them some stability of their case and gets removed to family court. Is MOCJ doing anything to address this problem?
So we are aware of the gap, and we are working with our partners to try to figure out what filling that gap looks like. There are programs that are available for youth in other areas, and we also have a pretty robust reentry programs as well.
Yeah, I mean, that's one of the biggest things that I'm hearing, that transfer kids are, it's destabilizing them. And to me, it doesn't make sense when it's all city programs. So if the program is working for a young person and just because they are moved in court, it doesn't make sense that we're doing it. And so I hate things that don't make sense. And this is one of the things that has been really grinding my gears around, like, is this serving the young people opposed to, like, who is it serving? Because it doesn't make sense. Like, even if you guys come up with another program, if a young person's in the program that's thriving and they're doing well there, why do you need to create another program for a young person to, like, have to get reacclimated to a new set of people? So we really have to make sure and figure out. I think when Raise the Age, we were, so excited about it. This was one of the gaps that I think that now we need to come back and reevaluate and really think about how to fix, because this is one of the things that I've been hearing the most concerned about. I'm going to bring up DYCD now, and then I'll turn it over. I have a couple of questions for DYCD, and then I will turn it over to my colleagues for some questioning, and then we'll come back around because me and Councilmember Chair Nurse has a few more questions for some of the agencies. Thank you. Welcome to the party.
Good afternoon.
Good afternoon. Well, it's still morning. We still got a couple of minutes. So one of the things, and one of the reasons why for me it's so important that DYCD is here and part of this conversation, especially when we're thinking about a decarceration plan for young people and getting young people out, because you guys get the young people in a recreational setting and typically before anyone else touches them. So I think that the role that you guys play is so critical and important, and sometimes it's lost in the conversation. And so for me, it's just thinking about what are we doing around making sure we're deterring these young people so that they don't have to talk to DOP or ACS or all these other things. So it's just really important. So NYCD Cure Violence Program is a community-based driven approach that focuses on proactively interventions and comprehensive support to reduce gun violence and improve public safety. ACS started the Close to Home partnership with other agencies to train youth to be junior credible messengers. Does ACS partner with DYC in efforts so that young people can grow into cure violence leaders?
Good afternoon, Chair Stevens, and thank you for that question. So, two things, I guess. One, we work very closely with ACS and all of our agency partners on the work that we do in both secure and non-secure detention. One program I do want to highlight that's an ONS program is our ACS Credible Mentoring Program, where we have those credible messengers who are placed at the secure detention sites, Horizons, Crossroads, and also some of the non-secure, providing meaningful connections to young people. It's a mentoring program. They're in there, they're doing workshops on critical thinking, team building, healthy relationships, conflict resolution, mediation, wellness, mediation, yoga. They're making those youth development style connections to these young people, so when they do transition back to community, they have those connections in place. They're also working with them on what's that, I put it in quotes, discharge planning that's happening. What's that resource planning, both for the family and that young person? As you know, well, our credible messengers are in community. So they're making those connections back to where those young people live, and it's been working quite well.
Is the Cure Violence program used to supplement ACS and DOP ATD programs? And I think I know the answer to this. I don't think they are, but just wanted to hear, because again, especially with a lot of the defense attorneys, we're hearing that like they feel like it's such a limited number of programs, and they typically don't have referral options. And so just thinking about are those programs ever used to supplement any of the other programs that ACS and DOP might be providing?
I don't want to call it supplement versus enhance, and also provide additional resources and services to what's happening.
Does ACS incorporate Cure Violence into aftercare for community-based programs such as Close to Homes?
So through our credible mentoring program, yes. We do have credible messengers that are at the close to home locations as well, integrated there, making, again, meaningful connections to those young people and supporting them in their transition.
What more can be done to improve communication between ACS, DOP, and DYCD and the Cure Violence program?
Oh, so we are great partners. The program teams speak at times weekly. What can be done to improve it? I think we have a great relationship.
Oh, you feel like you guys are doing a great job?
I think we're doing. I think we have a really good relationship. I think one of the things that and you know this, Chair Stevens, that we've been working on is how do we strengthen the relationships on the ground locally in community between providers, and that they're not competing, but they are thinking and partnering.
Yeah.
So we're still working and strengthening those connections, but it's coming across well. So that when they do make that meaningful connection to that young person, bring them back to community, that they can tap into other resources that are happening, whether it's a community center, after-school program, services for the family as well.
Yeah, and we should also be thinking about how are we preventing, right? Because again, that's, for me, DYCD, you guys are the first touch point. And so when they get to these places, we haven't done our job well. I'm going to leave it there and open it up for my colleagues. And I think right now, Councilmember Menon.
Thank you so much, Chair. So I have a number of questions. I want to start with the Department of Probation. I have to say, as I was listening to the testimony, I was rather shocked by the exchange that you had with the chairs regarding outreach to the judges, or more specific, the lack of outreach to the judges in terms of programming that affects young people. You mentioned that you have this monthly meeting with judges, and the only other aspect of the outreach you mentioned was handing out packets. I fail to see how that is meaningful outreach on an issue that is as important as the subject of this hearing. So why is the agency not doing more to reach out to defense counsel, to the Bar Association, to, there's so many different parties that you could be reaching out to, and just handing out packets and expecting that a judge is going to read that? It just is honestly shocking.
Thank you for that question, Councilwoman Menon. So the meetings that we have monthly is not just with the judges, but with all agency head stakeholders. So there is representation from legal aid, the defenders, all different councils, social workers, program providers. All of those entities are actually sitting at we do virtual and sometimes we do in person, but all the stakeholders are at the meetings.
Well, given the fact that the number of participants in the program, as you heard from the questioning from the chair, is so low, clearly the outreach isn't working. So it seems very apparent that the agency needs to rethink the way that you're doing outreach. Do you have materials that are on site at the courthouse? Are you reaching out to every specific defense counsel? You have the information about these attorneys. Are you reaching out to them directly? What exactly is the agency doing, and what is your plan moving forward to change the way that you're doing outreach?
Thank you for that question. So we also, when cases go back and forth to court, our CLOs have the packets that are disseminated to the parties in court. This is not this is something that we strive to do, but we will get back to council as to any other decision-making and outreach that we plan moving forward.
I mean, I think if I could make a suggestion to the chairs, I think that you should put together a new action and outreach plan that you submit to these committees for their review, because this is not working. And so, you know, one of the things, and I say this as someone who served as a former commissioner, one of the things that city agencies are supposed to specialize in is actual outreach. So I'm really concerned about the lack of outreach. I'd love to see a new plan that is submitted to the relevant committees so we can really take a look at that. My second question is for all the agencies. Since this is a hearing, an oversight hearing on coordination, just from hearing the testimony, I'm concerned that information is being siloed. What is the coordination between the 4 agencies that are testifying today? And if you could be very specific, how often are you meeting? But if you could really talk about the actual coordination between these 4 agencies.
So I can specifically talk about the programs that I oversee, our community-based alternative programs. We coordinate with DOP on a weekly basis whenever an exploration of alternatives comes in from the court to us. We are meeting with DOP to review that individual packet, which includes an investigation and report, a mental health report, and we make a decision together about which is the most appropriate agency to serve that young person. And then after, if JJI is assigned that case, they're also assigned a probation officer through DOP, and so that probation officer is regularly coordinating with our therapists who are in-home providing services and support. If the DOP probation officer feels like the young person should be violated, they are bringing it to the therapist first to have a conversation about it. Is this something that we can correct before we violate a young person? So we are regularly communicating with DOP on those types of cases. As Commissioner Rattay mentioned, we are regularly working with DYCD to get young people jobs, to identify internship programs. We took over the ATD programs from MOCJ. There was a lot of coordination that happened there. So that's just in terms of our prevention work, but also in our juvenile justice work, we also coordinate.
Okay, thank you.
If I may also add, I just wanted to clarify a statement that was made earlier when it came to diversion services. We are not a party to the outcome of the case when the case is referred to the law department, an investigation is conducted, and then if the case moves on to court, there's a CLO sitting in the court part. What can sometimes happen, as both chairs are aware and council members are aware, that the judge can also refer the case back to probation for adjustment services. So there was a memorandum that went out, basically, I believe in February of 2024, which states that we want to take a look at the cases, make sure that we are adhering to policy and making sure that we're working with the court in diversion services. So the case can be returned from court for diversion services.
Okay, thank you for that, because we had the copy of the memo, and so it was feeling a little frustrated to hear that. But since we brought up the outreach about the programs, while we've been in this hearing, we've been hearing from people in real time saying that as of this week and last week, they've been told programs are full. There was Staten Island reported they were being told by the court liaison that ICM is at capacity. Last Friday, they were told in a different location there were only 4 slots. So I don't know if information is flowing up to you so that you're able to fully convey what's happening on the ground. But it seems to be either information is not coming to you, or you're unwilling to say that you don't have slots. And I don't know which one is worse. But it just feels like this has been what's been happening in our last few hearings about these programs and questions about capacity. Is the statements continually saying we're ready, willing, able, we have capacity, but on the ground, people are being told no. So there's something happening, and I'm not here to hammer you personally, I'm just trying to understand what's going on. Because these defenders and these program providers are saying, this isn't adding up. So it would be really helpful if we could get actual clarification, whether from you or in a follow-up, in a timely follow-up, about what the hell is actually going on.
Thank you for that question, Chair Nurse. I met with the managers yesterday just for clarification of, what are the gaps? Why are we finding a disconnect with the messaging? And so my conversation with them was that the ICM referrals to probation were low, and you referenced Staten Island. Staten Island has 4 ICM cases.
I'm just letting you know what we're being told on the
understand.
ground. So I'm not there, I'm not a public defender, I don't spend my days in the court. There are people who do, and this is the information they tell us. There's no reason for them to lie to us. There's just zero benefit to them to lie to us, to say we are trying to get people in programs and out of detention, and we're being told no. There's zero reason for them to do that. I don't know what's going on, but I think you all need to have better communication at the ground level and at the higher executive level of this agency, because there seems to be some information gap that's happening. Because if this program, as you've testified today, and as we were told in the last budget hearing, is in fact doesn't have a capacity issue right now, that should be reflected on the ground. We should be hearing from people on the ground. Yes, we've been able, when a judge wants to refer, it's been able to find a slot, because that's not what we're hearing as of even the end of day, yesterday.
But also, I hear we keep saying the judges, but I'm also hearing from legal folks that the defense attorneys are the one that needs to bring these things up, and they do not know that these programs are not full, and they don't have a list of this information. So again, there is a huge disconnect, and honestly, it feels intentional. So that's where I'm at this point. It feels intentional because the numbers in our juvenile detentions are rising, and we keep saying raise the age. And so at some point, it's like, all right, if that was the case, we're there. So what are we doing to mitigate that? And so again, I think Councilmember Nurse said it. It's not a personal attack on either of you. I think you're just doing your job. But we, as a city, have to just do better. And for me, it's our job to push to make sure that we are doing better. And so that's where we are. But I do want to turn it back over to our council members, our colleagues who are here, Councilmember Aviles and then Councilmember Ressler.
Thank you, chairs. I think the one element that we're not considering here right now in this conversation about DOP and the judges and this outreach is that a question of confidence. Have you all assessed whether or not the judges actually feel any level of confidence in the programming that's being offered in order to refer cases there? Because judges are not going to refer to things they don't work or don't know about. And this disconnect is pretty profound. So it leaves me with one of two items. It's either lack of confidence in what the city is offering and or a lack of awareness. And both are lead to some significant work that needs to be done. So how is DOP assessing whether judges are confident in any of these programs, given the numbers of referrals that are happening? It shows no confidence in them.
Thank you for that question, Councilwoman Aviles. So the conversations with the judges are happening. They're ongoing monthly and ongoing with the stakeholders. I know that the last conversation that we had with the judges, they spoke about speedy trial and the fact that they need an MHS report before they can move to disposition. So we have some gaps, but we are messaging, and we're continuing to have conversations with the court, trying to find options to move cases along speedily so judges can reach the dispositions and utilize some of the robust programming that we have with AIM and ECHOS, which there is capacity, and we want the capacity to increase.
So I would advise you all to stop using the word robust. because the evidence that you've provided here to this council does not capture a robust set of diversion and prevention programs, the programs that we need. So I would suggest like a few. We're on our way, but robust is not reflected here. Certainly there's no robust numbers. What we're seeing of robust is the numbers of young people being detained, and that is unacceptable. The city has worked so hard to get our numbers down for juvenile incarceration, and we were innovating, we were closing facilities, and we are absolutely going in the opposite direction, and this is unacceptable. I guess I'd like to note that you mentioned there was a gap in the messaging, and I just want to note that what we're seeing here is a gap in action. We're seeing a serious contradiction. Now, if this hearing is about decarceration, adding beds to the system is not decarcerating. It is the exact opposite. So let's talk about the ACS facility. So my understanding is that there are plans to add, so there's ACS's decision to invest $340 million into the Horizon Secure Detention Facility in the Bronx is going to be adding 48 additional beds. I'd like to understand how this decision was arrived, what resources are necessary to prevent and move more youth out of secure detention. So actually, let's hear more about who made this decision to add more beds instead of doing the work that was previously agreed to.
Well, I'm not clear exactly what work you're referring to as to previously. We are working very hard to increase the number of community alternatives, and we are doing everything we can to divert young people and to work with the courts and council and the sheriff's office to place increasing numbers of young people on electronic monitoring. But I think there needs to be a little bit of clarification about that we're really talking about two different populations. The ATDs that we have been discussing today are for family court youth. We have very, very few young people in secure detention who only have pending family court cases. 3% of the young people in secure detention are facing charges only in family court. So 97% of the young people who are in Horizon and Crossroads are facing charges in the adult court system, and almost all of those young people before raise the age would have been on Rikers. And so although we have many young people in secure detention, we have no 16 and 17-year-olds on Rikers anymore. And we're able to hold the 16 and 17-year-olds who come to secure detention until they turn 21. And so overall, there is a much smaller number of young people under the age of 18 who are incarcerated in 2024 than there was in, let's say, 2013, because these facilities were filled with family court kids, and those kids are no longer in secure detention.
So let me just say for the record, we should not be adding one bed, whether they're coming from Rikers, or if the population is shifting at all. If our goal is to decarcerate, we should not be building beds. Those resources were allocated to, improve a facility. It was not allocated to build additional beds. So if I could just read a couple of questions for the record, and you can either respond. I can't, unfortunately, stay for the responses. It seems like they're going to take a little while longer, but I would like the administration to clearly respond on the record to these questions. So before building any beds or a consumption of additional beds, what did ACS do to cut down the population specifically? What ongoing processes are in place to reduce the number of youth in secure detention? What resources are necessary but currently not available to prevent remand or move more youth out of secure detention? How did ACS arrive at the number of an additional 48 beds? And what input process from community stakeholders, including young people and families, did ACS include when creating this expansion plan? And lastly, can you provide a breakdown of the $340 million? For example, how much of this is going towards increasing the number of beds versus overall improvements? And what does it cost to build each additional bed? I have many, many more questions, but unfortunately I do not have time. So we will submit them to you all on the record to expect a response from each of you. And they cut across a number of different agencies. But for the record, and lastly, someone mentioned, I think it was DOP around programs for NYCHA young people, and DOP just went randomly, willy-nilly, and cut Next Steps program, which was serving our NYCHA youth, because apparently in their mind, those services existed. And we told the commissioner 100% those were not duplicative services, and they went and cut them anyway. So there is so much work to be done here, and it is deeply disappointing to see how the agencies have started to roll back incredible work that was being done, where we were innovating and decarcerating in earnest, and now we are totally doing the opposite. It's deeply disappointing. And our young people deserve better.
Thank you. Thank you for your questions, Councilmember Velez. I'm going to turn it over to Councilmember Nurse, who has a few questions.
Just a couple more questions. And welcome, Councilmember Natasha Williams. I wanted to ask about adjustment again, and I wanted to ask about adjustment when top charge is a criminal possession of a weapon. So in particular, can you describe how probation officers assess whether to recommend adjustment when the top charge is a criminal possession of a weapon? And has there been any recent guidance given to POs related to adjustment considerations for gun cases?
Thank you for that question, Chair Nurse.
I'm sorry, I can't hear you.
I'm sorry. Thank you for that question, Chair Nurse. So when I reference that suitability diversion is based on the statute, we are informed by the statutes, which is Family Court Act 308.1 and the Uniform Rules of Family Court 205-22. So basically, the statute enumerates a number of offenses that cannot be diverted, which is one of them would be criminal possession of a weapon first degree, and also a criminal possession of a weapon second degree. Those are weapons cases. But the statute looks to the legal history of the young person and also the nature of the offense that comes before us at intake. So those are the areas that we that informs our decision to divert the case or to refer the case to the law department.
Okay, and there's been no internal directive to probation's officers at all about this?
There has been no
telling them
internal.
not to adjust gun cases or not to even recommend?
That is correct. No internal directives.
Okay. One second. So the most recent MMR also noted that the number of enforcement actions conducted by DOP's intelligence unit more than doubled, and the agency has been increasing the number of cyber or social media investigations. What is the rationale behind DOP's recent focus on increasing enforcement actions, specifically in the context of the cyber social media investigations?
Okay, thank you for that question. Unfortunately, that is not under my purview. I am not the subject matter
Is there anyone
expert.
here
for
whose
Intel.
purview it's under?
No, there is not.
And would you cannot speak to under what circumstances would a probation officer who supervises a juvenile conduct a field visit or monitor social media accounts?
All our probation officers are trained to manage risk. So they are looking at social media accounts. They're asking the young people to share their social media links, accounts, names. So they're monitoring that way. So we do have internal engagement with our young people who trust that we're trying to keep them safe as well because the streets are dangerous. So the young people are sharing their social media links with us. But again, I'm not the subject matter expert to talk about cyber intel.
Okay, we'll submit this question for follow-up for a more detailed answer. And just my last question, because you alluded to it in your testimony about the reporting requirements in Intro 87 and 977. And I wanted to state for the record that nobody here in the council likes to do reporting bills. In fact, we hate it. It's not the legislation that we love to go home and tell our constituents, oh, we're getting an agency report on information that we wished they would willingly just share with us when we ask them questions at a hearing or when we're doing government-to-government interactions. But you're saying that the frequency is too much. What would be your alternative proposal for us to get this information that we seem to struggle to get, if not through a reporting that was frequent?
We will be meeting with, our commissioner and council, and we will get back to council members on our challenges with the bill, if any.
Okay, it would be helpful to have any specific operational barriers because it's just data.
Okay.
Those are my questions.
Councilmember Ressler?
Good afternoon. Oh, good afternoon. Yeah, more or less. Thank you, chairs, for pulling this hearing together. There was a lot of data points that were shared around our census and the trajectories and comparisons to other cities in the opening testimony. I just want to make it crisp. The current census today at Horizons and Crossroads is 240. So since the mayor took office in January 22, the population was? When the mayor took office in January of 2022, the population was 152? 152. So what we're talking about is a 125% increase in 2.5 years in office in the number of kids who have been jailed on any given night. Is that correct?
Apparently, yes.
It is. Thank you for the record. So what's your plan to reverse this? What are we actually doing to drive down this population immediately? What are the investments that, I'm not even asking the other agencies because I know that they're not invested. What is ACS doing to actually drive down this population today?
There are a number of things we are doing, but I think we need to define some terms. The young people who are in detention are in on very serious offenses, the vast majority of them. So 1/3 of our young people are facing attempted murder charges, 1/3 murder charges, 11% gun possession, 18% robbery charges that involved a gun. So we are working with the courts to ensure that young people whose cases can be removed and can be stepped down to non-secure detention, that consideration is being made. We are working with the Sheriff's Office to ensure that young people who can be interviewed for electronic monitoring, those orders are being made by the court.
I hear you, but I'm not seeing any progress in our census, right? We have a census that keeps going up, that has been up and up and up. The number of gun charges year over year, according to the mayor's management report for for these minors went down, and yet the number of kids who were jailing went up when we've heard repeatedly that this is the main issue. So I'm just troubled that we can't cite specific investments, tangible actions that we are taking beyond we're talking to the law department, we're talking to the judges. I think we all want to hear what are the actual steps, the programs, the initiatives, the referrals that we're making to reduce the number of kids that are incarcerated. Well, let me actually go to impact, because I think there were some questions about next steps, there were some questions about arches, but I think the program that would make the biggest impact in reducing incarceration, the program that would make oh, that's, I guess, cute. The program that would make the biggest impact in reducing our youth incarceration, which again has skyrocketed under Mayor Adams, is the impact program. And I know, ma'am, that you said that you're not prepared to speak to any of the programs that the Department of Probation runs and why they've been cut. But I'll just ask again, are you or is any of the other people here from the Department of Probation prepared to answer why the impact program no longer exists and how consequential it would have been in reducing incarceration today, unnecessary incarceration today? And again, for those who don't know, I'll just say on the record, impact was designed to help youth who are primarily sentenced as juvenile offenders or youth offenders address issues related to their wrongdoing through two main components: in-home family services and mentoring. It's an evidence-based, highly successful program. A provider was identified to run the program, a very capable provider in cases, and just on the precipice of implementation, for reasons that I still cannot fathom and have not heard any explanation whatsoever, the program was cut. It would have made an enormous difference in addressing the overcrowded conditions and the skyrocketing rates of youth incarceration that we're experiencing under Mayor Eric Adams. Does the Department of Probation have any explanation for this at all?
Thank you for that question.
Thank you.
Councilman Ressler. So, although I'm not the subject matter expert for the impact program, I know that our commissioner testified at the last hearing that we have other programming, such as the mobile adolescent portable therapy program that supports and serves the needs of all our clients in family court and in the youth part, and we are looking to expand that program as well. But I also wanted to mention, in terms of decarceration, we have probation officers working round the clock, 7 days a week in detention cases for evening intake, night court, and weekend arraignment, to move kids faster through the system, to identify resources in the community to release them from detention, and also to expedite, if the case is going to the law department, to at least release them into the community if they're in non-secure detention, if they're suitable for release.
Mind if I keep going? Okay. I'd love to ask some more questions then on that. Let's go. So, of those cases, let's just, how many juvenile arrest cases has DOP reviewed in the last month?
Could you repeat that question?
How many juvenile arrest cases has the Department of Probation reviewed in, let's just give a set a time period, last month? Or if you'd prefer, we'd be happy to take the information in writing and take the information back over a period of time.
Yes. So in citywide year 2024, we received so far 3,478 cases. Of those, we referred 2,623 cases were referred to the law department, and we opened 801 cases for diversion services.
So 801 cases for diversion services out of the 3,074 that you reviewed, 2,070, so two-thirds of those cases. I'm in broad strokes here. Two-thirds of the cases sent to the law department for prosecution, for potentially sending more kids to jail. Just one-third of the cases were sent for diversion, less than one-third, 800 out of 3,000, so 28% sent for diversion. Is that broad strokes? We're on the record?
We are guided by the statute, and the statute determines suitability, not the Department of Probation. So if the statute enumerates the types of offenses that may or may not be diverted, whether or not the case is suitable based on the young person's legal history or the nature of the offense that comes before
And
us.
if we had additional programs in place, additional options like Impact, like Arches, like Next Step, that the Department of Probation has all eliminated, it would have no bearing or impact whatsoever on the number of young people that were sent to diversion?
We have other programming, such as the one that I mentioned, the mobile adolescent portable therapy program. That
How many people is that program serving? Because I thought it was it that the 12? 12, okay. So that's great that there's 12 kids in the program, but we're talking about a program that's jailing 250 kids tonight, 240 kids tonight in our detention centers. So we had 3 very effective, successful programs that this leadership of the Department of Probation under Mayor Adams has cut, and we still have no reasons or explanation for them despite the success of those programs. The Impact program in particular would have been most consequential in reducing incarceration. We had a great provider lined up, the funding was in place, and then unilaterally, all of a sudden, without explanation, the program is gone. And I just don't understand it. And I don't understand when ACS is literally bursting at the seams, and I'm going to come back to you in a second, why we would ever cut these programs that allow for more diversion opportunities and reducing incarceration further. We've seen a 125% increase in kids sent to jail since Mayor Eric Adams came into office. We could have reduced that number if we just funded the diversion programs that work, but we've chosen not to. And I just don't understand how any of this makes sense.
To emphasize again, Councilman Ressler, suitability, diversion is based on the statute. The statute informs our decision. If we are diverting a case, we have to look at suitability and what the statute provides as suitable. If the case is a designated felony, the case has to be referred to the law department and to court, and only the court can make that decision to divert a case.
And I appreciate that you're not responsible for running these programs. You explained that clearly to Chair Nurse earlier. I wish that we had the appropriate team from DOP that was here to answer those questions and to speak to this because it's so central to the purpose of the hearing. And so I'm just a little confused. I appreciate you being here and appreciate you trying to answer our questions, but I'm just a little confused how we don't have the right people in the audience that are coming up to the panel today to join us to answer these questions if it's not in your portfolio or why they wouldn't have been sent here in the first place. It makes the whole experience a little frustrating. So I just want to come back on ACS for one more second if that's okay, and then I'll shut up. Could you just go through with us the status of ACS's waiver from OCFS that allows the young adults, the kids, to sleep in classrooms? Is that currently in place?
Yes, it's effective till November 8th.
November 8th. And we have capital projects planned to expand the legal capacity of the number of kids that were permitted to jail in our youth detention facilities. Could you speak to what your intentions are for how big we are growing these new jails and the amount of capital money that's associated with the renovations to expand these new jail facilities?
We have plans to build a 48-bed facility with additional programming and educational space. It will have space that is appropriate for the age group that we have. We are essentially creating an emerging adult facility for the population of emerging adults whom we are holding.
Okay.
So
and the cost?
$340 million.
$340 million. So I'm going to say this in closing. We're spending $340 million to expand our youth detention by 48 beds. So we will go, because when you build the beds, we're going to go from 120-something beds when the mayor came into office, 240 today. We'll be at 300 beds or so at the conclusion of this project. We will have nearly tripled the number of kids that we're sending to jail. We're going to spend a third of $1 billion on this project. We could have spent tens of millions of dollars over years to reduce the number of kids that are in jail, but the Department of Probation has cut the programs. We have kids currently sleeping in classrooms that we've had to seek a state waiver to allow for that don't need to be there, but the Department of Probation has cut the programs. I just think we should restart these programs under ACS. We should fund them properly. You all are responsible for managing the census. You all should be responsible for investing in the preventative programs that keep our young people out of jail. I wish we need an agency that's committed to this. I don't know where else to look. So thank you, chairs, for the hearings. This is a really, really important topic, and I really appreciate both of your leadership on it.
Thank you, Council Member. I just want to jump in because I feel like the three of us have just been harping on this same lack of investment in this program. And we keep being told the statute describes what you can recommend, and it just feels like all throughout this time that I've been chairing this committee, DOP repeatedly just kind of avoids taking responsibility for the situation. You're not screaming loud enough about the programs you have. You're cutting the programs. You're saying you don't have jurisdiction, basically, but I have what you sent over last night, and there's so many factors in which you can consider whether or not you want to recommend or not. A gun charge is just one. There are so many other factors in here that you could be considering and saying, we recommend this case be adjusted. You all have every right to say, this person should not be in detention. We recommend this to be looked at again, considered through all of these lenses that are prescribed here, and diverted. And I'm just feeling like there's a lack of responsibility being taken here at all. Not just with youth, but with the adults as well. In all of our hearings, we've heard DOP has one of the biggest roles to play in decarcerating our city. Your folks are not even paid well enough. You probably don't even have enough folks, but you're also just not stepping up and taking responsibility for it. And it's just really shameful. You're saying, what is the suitability of diversion? You have a ton of factors here that you can look at and say, this person is suitable for a diversion program. And you're not doing it. And certainly with 12 people in just one program, that's just a failure. So I thank you for sending over these guidelines, but we got them last night. There's a lot here to consider when looking at someone's case, and it feels like you're not considering it fully.
Well, thank you for that question, Chair Nurse. But we are considering all the factors that are under suitability. And what we're seeing are young people that are repeat offenders, young people that are not suitable for diversion services based on the statute. So I understand your concern, but we are guided and informed by the statute. So we're not just looking at the enumerated factors, we're looking at the young person's legal history and whether or not they have an extensive legal history that warrants other intervention and other avenues. So we are looking at all the suitable factors. We understand that we play a crucial role, an integral role in the decarceration of young people. But again, we are guided by the statute.
I would love if you could provide in the follow-up of all your cases this year, the percentage of repeat offenders, because I see that's one of the indicators on here, so we can understand. And then based on the number of cases you provided in your answer to Councilmember Ressler, there was about 800 folks that weren't diverted. Roughly, it was a quick math. We'd love to know kind of an understanding of what is the general makeup of why those cases couldn't be diverted, to help us better understand where you all are coming from. Thank you.
Thank you.
Councilmember Williams?
Hi, I just wanted to know what the statute stipulates around suitability, but is that what you have? Oh, okay, can you share what the statute stipulates around suitability and what I would say subjective flexibility do you have to even interpret the statute? Because, I think there's some levels of subjectivity that you have to interpret or not. Maybe you don't, so that's the question.
Thank you for that question, Councilwoman Williams. We do have, and we can share the suitability factors with council. It's a long list.
And do you have any subjectivity to interpret the statute, or is it objective in nature? Like, if this young person, is a repeat offender, is that a hard line, or are there other things that you can interpret within the statute to potentially divert that young person? That's an example, but I'm just trying to understand based off of even though I was listening, even though I wasn't physically here, I was listening into the hearing. So just based off of listening to this discussion, trying to ascertain if any at all flexibility you have in your decision-making power to divert, because that seems to be like the place of contention, especially in your response when you say, okay, well, we're bound by a statute. Great, we all know there are rules and laws we have to abide by, but what, if any, flexibility do you have when you're interpreting the statute and making recommendations to divert?
Thank you for that question, Councilwoman Williams. We don't have any subjective thoughts to this. It's the black letter of the law. So again, I will be more than willing to share the suitability factors with council because the statute is very clear on the types of cases that must be referred to the law department and the type of cases that we can consider for diversion services. So it's the black letter law.
Okay, thank you.
Well, I only have a couple more questions, but I just want to make a statement for the record as well. And I think for me, when we were preparing for this hearing, one of my questions kept being like, is this policy? Like, and just trying to get to like the thought of it, and just to even hear like it's the law and all these things. But I think that even with that, it's still left up to interpretation. So we get to decide how we interpret things and how we move forward as a city. And if we are in a if we're saying we want to decarcerate, then we will do the things to do that. Because if you look at years past, DOP was thriving and bringing in more programs. Like that was what was happening. There was a programs coming in, it was a plethora, it was a direction that they were going. And so now I think the frustration is when we're seeing that programs are being taken away. And by the way, I also want to note that even in prior years, the programs also had very low enrollment. And so it's like, okay, are they low because it's very expensive to operate them? Is it low because young people don't need it? Just trying to get a better understanding, and it's not a lot of information for us there to pull, which also to me is problematic. But for me to see that we are eliminating programs that we know that are working, it starts to feel intentional. And so if the numbers are rising in the facility and forces ACS to then have to expand because we don't want to have young people sleeping in classrooms and we don't want them to be uncomfortable and not have enough space, then I think that we have to take a moment to stop and evaluate, which we don't do in the city, which is why it's the most frustrating thing ever, because every response is always like, well, things have been different since Raise the Age. So at what point do we say, okay, let's stop, evaluate to see, we have a new circumstance, we have a new law that's in place, so let's evaluate to make sure that we are doing all the things that we need to ensure. And I know you guys say all the agencies meet once a week, but is that effective, right? Have we stopped to say, like, is this working? Does that make sense? And so it's just very, for me, frustrating, because it's like, I don't care about any of this. What I care about is that young people are in detention. Everything else to me is null and void. My goal is always to protect and advocate for young people. And so I just want to just say our frustration, one, is not at people individually, but I run around the city and say, I'm in charge of all the babies now, right? I have DOSC, I have ACS, and they're all my babies. And so for me, if we have 240 young people detained every night, I have 240 babies that are mine detained. And so I take it personal. So I think that's some of the frustration. So I just wanted to state that before I ask these last couple of questions. So this question is for ACS. There's a number of reports around staffing challenges, especially in the secure detention facilities. And so just thinking about what this expansion, what does that look like? Because I know when we're here, a lot of times you guys are like, no, you're good on staffing, everything is fine. But then again, we're hearing on the ground that is not the case, that you are understaffed, staff is stretched thin. And so what does that plan also look like, and trying to see how we're gonna move forward?
So our staff retention rates are better than they have been. We hired 262 youth development specialists in 2023 and 126 in the first 5 months of this year. And we are seeing fewer of our staff going out on workers' compensation. We're seeing more staff who we are hiring staying. So we are hopeful that that trend will continue and that we will be in a position to fully staff the additional space.
And I think that even with that, that is frustrating because we know this ecosystem of staffers, and one of the things that our nonprofits are always screaming about is that the staff is being stolen because of pay parity, which is a huge issue. And so even with this expansion, how was that considered? Because it's gonna throw the equilibrium off, because people are going to leave the nonprofit work that's, you know, in those facilities and working with those youth there to go there because it's more pay. So even with this, and I think for ACS and all city providers, like I feel like sometimes you guys don't think about that, because a lot of times they'll leave the nonprofit to go to you. And so how are we assessing the ecosystem when we're expanding to understand that it's gonna have negative effects in other parts of the system that you also fund and supervise and have to be a part of? And so just trying to just think about how is that also being assessed and brought into the conversation.
So we're actually having these conversations. We're in regular conversation with the provider agencies that run our non-secure detention and non-secure placement and limited secure placement close to home. And we do understand that there is not an infinite pool for these positions. It is not our goal to fill all of the 48 beds in the new facility. It is
if you build it, they will come.
It is our goal to build age-appropriate spaces for our young people so that we can move them out of the current spaces where many of their needs are harder to meet and into spaces where they can participate in larger classrooms, have access to dedicated vocational spaces, have better and larger mental health treatment spaces and medical spaces.
And listen, I've had this conversation, I've said this on record, off record, and all the places. I understand the need, right? But for me, if we would have done the work and not cut the programs, we wouldn't have the need now. So we're at a place where it's like, do we want kids sleeping in classrooms, or do we want to have to build a facility? And it's like, we have set it up so we can get to this place to say, well, what do you want? And so, you know, here we are. So that's my take on it. And here's the thing, you as ACS, it is your job to make sure the kids are in a safe space. And so, of course, you don't have much of a choice, but I think that that's why the frustration is DOP, who has the power to actually reduce the numbers, that clearly is sinking. And I'm not letting DUICD off the hook either, because if we had programs that was keeping these kids from getting involved and having these gun charges, then that would also be helpful. But obviously, it's not working. So for me, it's the frustration of it all. So DUICD would like to come back up to the front. I have some questions before I close out. So this year, the New York City Council data team published findings that during the first year of the Cure Violence program, precincts with an active Cure Violence program experienced a 17% reduction in shooting. Given the proven success, how will cuts to Cure Violence programs in FY 2025 budget impact imperative care in critical communities?
Chair Stevens, there are no cuts to Cure Violence to the Cure Violence.
All right, the pegs.
So got you.
Okay.
The pegs are not with the Cure Violence work. The Cure Violence work is.
So are we not? So was there not a peg where the legal aid is now being reduced? I just want to don't do the semantics.
The difference between the Cure Violence work is the teams on the ground who have catchments in communities, and that's specific work.
But all of this is connected, and so I think that's also part of the problem, that we try to siphon it off as if all this work is not interconnected. And when we start piecing it off, that's part of the problem. And so I know it's easier because for funding purposes, we like to talk about them, but the reality is that is the whole ecosystem.
Yeah, and it's all part of, to your point, Chair Stevens, all part of the crisis management system and supportive services. During that time in November, we had to make some dire unfortunate decisions around the funding. And we did cut legal aid in half. I want to say their current budget for FY25 is going to be $1.5 million. The team is actively working with them on what that work plan looks like going into FY25.
So at the budget hearing, the commissioner and yourself testified that you were guys having a meeting with those groups. Could you tell us the findings of those meetings and what the next steps are and what the outcomes were?
Yep. That meeting that we had,
Because it was scheduled the day after my hearing, although y'all told them the day before my hearing, but.
It was scheduled for that next Monday after the hearing, and that was scheduled before the hearing, on the record.
That's what I just said.
I just want to make sure. The meeting was, again, affirming the cut, and then talking about potential ways that it impacts going forward, and then we started a process where they were submitting to us their proposed plan.
Okay. I guess the last question I have is just thinking about, and I think ACS kind of already alluded to it with the JJI program around just my concern, especially around with young people who are homeless and runaway youth, and how are we making sure we're providing services for that population, and what is DYCD doing as far as support who are in your facilities and your homeless shelters that the homeless runaway youth young people
Nice.
are in?
Two things I want to call out. One is our, and of course, and you know this well, our Summer Youth Employment Program, where on the emerging leader side of it, where we create an opportunity for young people with those barriers, whether it be homelessness, whether they are justice involved, or youth aging out of foster care. We do get referrals from the agencies, whether it's ACS or Department of Probation as well. So we're ensuring that those slots that can bypass the lottery, because these young people have these circumstances that they're dealing with, that they get work during the summer as well.
So that's the only thing that you have to, is there additional services for young people who are in homeless runaway system that might
Of
be
course,
currently involved? Could you
we
talk a little
have,
bit about those
absolutely.
programs?
So as you know, we have 813 shelter beds throughout the city, or RSRI beds. 60 of those are for our older youth population as well. We also have the drop-in centers and 24-hour drop-in centers across the city where young people can go get services, also be referred and get to other services as well.
But I'm asking more specifically, do we have like specific, like if you are court involved and you have some of these other issues, like do you guys have like specific supports for them who are in the homeless runaway youth shelter? Like is there specific supports?
We do. We have, there are in most of them, there are case managers who are there who are working with those young people.
They would be the ones kind of ushering
working with those young people, triaging, creating an action plan, if you will, for those young people and connecting them to those resources.
Okay, I think I'm complete for this moment. Do you have more questions? Nothing to answer. Well, I think at this time, this is the conclusion of our questions for you guys. Thank you all for coming in to testify. This will not be the last time, because we have a lot of work to do and really want us to be working together collaboratively to create a real plan around getting these numbers down in a real way. Thank you.
Thank you.
Wait, my pen. I would like to, before we go to public testimony, I would like to acknowledge Councilmember Rita Joseph and Councilmember Shahana Hanif, who's online, who has joined us. I now open the hearing for public testimony. Sorry, behave. I remind members of the public that this is a government proceeding and that decorum shall be observed at all times. As such, members of the public shall remain silent at all times. The witness table is reserved for people who wish to testify. No video recordings or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but may submit transcripts of such recordings to the Sergeant at Arms for inclusion of the hearing record. If you wish to speak today, at today's hearing, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When recognized, you will have 2 minutes to speak today on today's hearing topic, coordinating the administration youth decarceration plan. If you have written testimony or additional written testimony you wish to submit for the record, please provide a copy of that testimony to the Sergeant of Arms. You may also email testimony to testimony@council.nyc.gov or other emailed address within 72 hours of the hearing. Audio and video recordings will not be accepted. I guess I'll call the first panel, and I will apologize in advance for butchering everyone's name. I think this is Jackie Gosadin? Nida, what is it, Chet? Nadia Chi. Oh, are you sure it's a T? I don't know. Christopher Jeffries. Cecil, what's this, Treasure? Teber. I'm sorry for butchering your names. And I will continue to say that because I'm going to probably do that for everyone. Thank you. You may begin, and then one may begin.
Can you guys hear me? Okay. Thank you, Chairs Nurse and Stevens. My name is Jackie Gazdigian. I'm Supervising Policy Counsel with Brooklyn Defender Services. I've also been a public defender for 15 years, and I work closely with our adolescent representation team at BDS. Our adolescent representation team works to eliminate contact with the criminal legal system for court-involved youth aged 18 and under. In order to decrease the population of incarcerated youth and break the cycle of re-arrest, it is imperative that we focus on alternatives to detention and keep our young people in the community with their families while providing them with the supportive services they need. Once a young person is arrested, as you heard, they may be able to access an ATD or alternative to detention program. In Brooklyn, that program run by ACS is Good Shepherd, which provides mentorship and guidance for our youth, but this space is extremely limited. We urge the city to increase funding for these ATDs and for additional ATDs run by community-based organizations that have a proven track record of building trust with families and offering resources that meet the needs of families. Programs such as Esperanza, which operated in New York City until it lost its funding, the Youth Justice Network, Exalt, and Community Justice Innovation are just a few examples of effective and trusted programs that are becoming less accessible and have less resources. Also, according to the director of our adolescent representation team, both ICM and Good Shepherd are full in Brooklyn. She was told this morning that there are no spots available in either. Raise the Age is working, and youth crime has consistently decreased since Raise the Age implementation in 2018. But we must truly invest in programming to support these reforms. For example, the youth parts in Supreme Court are severely lacking in resources needed to effectively divert youth from incarceration. Judges are willing to resolve cases with alternatives to incarceration, but the programming is limited in each borough and there are significant gaps as probation has disinvested in important diversion programming. I also want to address probation's comments on diverting cases. The reason less cases are being diverted is not because the charges coming in are more serious. In fact, the more serious cases are being retained in Supreme Court. Can I just follow up here? Probation, in fact, probation won't divert on any gun case, even D&E gun cases, where a gun is found in a car with multiple young people in the car, for example. They will not divert on any of those cases. We thank the City Council for holding this important hearing today and shining a light on the experience of young people in court that are court involved. We urge the city to continue to invest in real prevention by investing in young people and their families, schools, and communities. Thank you so much.
Good afternoon, and thank you for the opportunity to testify today. I'm Nadia Chait. I'm the Senior Director of Policy and Advocacy at CASES. I want to thank the Council for your commitment to attempting to get answers for why the IMPACT program was canceled. And I'd also like to highlight something about the program that has not come up. It is true that we also operate adolescent portable therapy. We believe in the program. In-home family therapy is an important service for young people who are experiencing interaction with our criminal legal system. However, IMPACT was a two-part program. One part of that was in-home family therapy, but the second part of it was credible messenger mentorship. That is not a part of APT. It is not something we are funded to do under APT, and it is critically important for the kinds of young people who would have been served in IMPACT to have that service, to have a trusted individual who has, in many cases, quite literally walked in the same places and the same shoes as that young person, and who has changed their life, and who can really connect with that young person on a deep level around alternatives that are available to them to help them turn away from violence. So I did just want to highlight that. I will also say, in terms of next steps, that while the Commissioner and the Department of Probation generally have talked about, oh, it was small, each site of next steps was 16 young people served, and there were over 10 next step sites. So it was serving over 100 young people who are at high risk of being the perpetrators or victims of violence, or in many cases both. And so when we look at youth detention numbers increasing, and we look at a program that was serving over 100 young people in our city with the intensive services that they need, these programs shouldn't always be giant programs. This was a program that was really intended to serve a small group of young people with very intensive services. It's not a program that thousands of young people needed, and so it was appropriately targeted. Happy to answer additional questions about our programming, and I thank the Council for their focus on these issues.
Good afternoon. My name is Christopher Jeffries, Chair and Committee. Thanks for having me. I'm currently a youth advocate for a nonprofit organization called Bronx Connect. Previously, before my tenure here, I was a youth development specialist in Crossroads. So I'm speaking from a standpoint of comparison and contrasting between the two. In my experience, I find that alternatives to incarceration work far more better than incarcerating. Whether we're talking about youth or adults, the recidivism rates are way lower. We have a 98% success rate at Bronx Connect with our people who finish the program. At my time in Crossroads, I seen the revolving door for myself, young people going out and then coming back in. So that tells me that the real issue is poverty in our communities, lack of resources in our communities. At my time in Crossroads, we were stretched thin staff-wise. I can't say if that's changed or not, because I've been going since last year doing youth advocacy, and I see that ATI provides more resources than incarceration. We help with family functional therapy, individual therapy, OSHA training, all sorts of other resources, trainings that these young people can utilize once they leave the program. And I just wasn't seeing too much of that inside of Crossroads. It's more of a jail setting, so they don't get to learn the things that they need. There's no law library for them to study their cases. If the school teachers decide not to come to school, they don't have classes for that day. Yeah, that's my time, so thank you.
Hi, good afternoon, Chair Stevens, Chair Nurse, and committee members. My name is Cecilia Tuber. I am a community organizer at Bronx Connect with my fellow colleague, Christopher Jeffries. Since 1999, we've served over 2,000 young adults and youth in New York City, which has been amazing.
So at Bronx Connect, our alternative to incarceration program is one of our most successful. And the purpose of incarceration is to hold individuals accountable for the crimes that they have committed. And also just to deter them from reoffending upon their release. What we're seeing is simply that incarcerating young people is not working. It's actually leading to, more incarceration rates or higher incarceration rate. And actually exacerbates the person's situation and can make them, more likely to offend. So what actually works is looking into the why and addressing those issues. This is exactly what programs such as ATI, ATDs, AIM, things of that nature do. At Bronx Connect, youth in these programs receive proper mentorship and wraparound case management. And also, as my colleague spoke about, all the other, programs that we have. So anger management, self-harm classes, things like that, OSHA trainings, and we take responsibility for the cost of those so that we can lead them to a better and brighter future. And so, one thing that we do is we meet the individuals where they're at. So we see where the need is met or where there are unmet needs, and then we fulfill those with the programs that we have. And if we can't do it internally, what we do is provide them, a connection with one of our, partners across the state. And by looking at, so when I talked about really looking at the why, by looking at the underlying cause of crime and diverting our youth from incarceration early on, we're able to work with them and address their issues and give them a second chance. Do you mind if I just have one more moment? And I know your time is valuable. But really the proof is in the numbers. So in a 2018 study of our ATI felony program with our ATI felony program graduates, 97% of those remained felony conviction free within 3 years of being released. We're just seeing right now, how successful these are, and I wish that I could tell you all the stories about the people, not just tell you the numbers, but about the young people who've been through it, and what opportunities they have now, and how they are, have been diverted from a life of crime. And it is really wonderful to see, and it shows again that these programs work. So again, thank you so much, Chair Stevens, Chair Nurse, and committee members for letting me speak today. Thank you.
Thank you so much. I would like to acknowledge Deputy Speaker Ayala, who has joined us. So I had a question, and I know Councilmember Williams has a question, but I just wanted to follow up because in today's testimony, we kind of heard a little bit from Department of Probation, and I guess this is for the Bronx defenders. You started to talk about it in your testimony. Could you just talk a little bit more about how you haven't seen the diversions that they said that they are doing, and that they're bound by the law and blah 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 blah? If you can give us more insight on your experience.
Sure. So what we're seeing in Brooklyn is that what's been happening, what's been very common is that NYPD will arrest groups of young people. They won't just arrest one young person, they'll arrest groups of young people. And so what's going on, particularly with the gun cases, and when I say D and E, those are the lower level gun possession charges. The E charges actually used to be a misdemeanor. Those cases are not being diverted at all. So they're all being referred to the law department, even if it's someone who is sitting in the back seat of a car, for example, and a gun was found in the trunk or a glove compartment. They're not exercising any discretion where they could, even within the letter of the law, to divert these cases. They're not doing that. And by them saying that the reason why less cases are being diverted is because the more serious cases are coming through, that's not what's happening. Those serious cases are actually being retained in Supreme Court. They're not being handled in family court. So those cases have nothing to do with probation's decision to divert or not. Does that make sense?
No, I think it gives clarity. No, I really appreciate it, because I think that even we know it was semantics, but it's really good to have it on the record around like what is actually really happening. So I'll turn it over to Councilmember Williams and then Councilmember Joseph.
Yeah, I think I was going to ask a similar question to the chair, but discretion. I think that was the word I was looking for when I was trying to ask this subjective versus objective question. And so from your vantage point, what types of discretion do they have? Because I think they, in the testimony, sort of alluded to this idea of it's black and white. Like if the case fits these things, there's no discretion or, I was saying subjectivity around the decision they could make to make a recommendation for a diversion. So if you can just share, like, what types of discretion do you think they have? Is it that they have to explicitly go by what the statute says? I'm looking forward to them sending the statute on what is suitable for diversion. But yeah, I'm just wondering from your vantage point, what discretion do they actually have?
Sure. So the discretion is similar to that happens in adult court. So let's say that the police decide to arrest all of the people in the car, for example, and charge them all with possessing that firearm without a license, right? Those charges are then brought to the district attorney's office for the adult courts, and then the district attorney's office makes a decision about whether or not the charges are going to proceed for everyone. Probation in family court has the ability to decide which cases to recommend to the law department and not. So they actually don't need to bring a case for every single one of those young people, but instead what they're doing is just passing everything along and not diverting any of those cases if there's a gun. So they're saying there isn't a policy, but as far as we're seeing, their policy is that if there is a gun involved, that under no circumstances, regardless of what the facts are, they are not diverting any of those cases.
And do you think that's specific, because you are giving like a very specific case where a group of young people get arrested, like, which is kind of what I was sort of trying to get at, like, each case is different, and the facts of each case is different. Right. And so are there other examples outside of this one where there's a group of people that got arrested, maybe 3 of the 5 should have been diverted, and maybe 2 potentially should have been referred to the law department, but do you think there are possible discretions in other types of cases, or do you feel the most discretion they have, which seems to be suitable, I use that word, suitable to have, or relevant rather, given what you mentioned around how cops are actually incarcerating young people in groups? Mm-hmm. Is it just like the group thing that gives them discretion, or do you think there are other cases?
No, I think there are other things, and I think they actually testified. They talked about how they looked at someone's, history of involvement in the legal system and then made a determination based upon that. So, I mean, there's a number of factors, and whatever analysis they're going through internally, at least as far as guns are concerned, the analysis is not. They're not using that analysis to allow themselves to divert. So they're basically defaulting to sending them all to the law department.
Thank you so much. So they're not using any of the data to drive that, right? So I know I was hearing earlier that under this administration, our numbers have gone up in young people being incarcerated. So what are we doing with that data in order to make sure that we're not heading in that direction? What are you seeing on the ground as attorneys? What should we be doing along with the non-for-profits, the stakeholders? This is everybody's game in it, right?
So, once the public defender's office gets involved, then that means that the petition has been filed, the recommendation has already been made. So I do think that, yes, diverting more cases without referral would certainly drive the numbers of youth incarceration down. I think once the cases are proceeding forward, that there needs to be more alternatives to detention and more alternatives to incarceration. I think it's pretty clear that the judges are, at least when we are asking, we know what the options are, and we are asking for judges to use alternatives to detention instead of incarceration. And in many cases, they are willing to do so, but then they're being told that these programs are full, either ICM or Good Shepherd, which is the ACS-run program in Brooklyn.
How many can Good Shepherd take in?
I don't know what the actual number is. I mean, what we were hearing that the space is unlimited and that they don't, I think they said that they had not had to turn anyone away.
Yeah, it's unlimited now. It's expanded. They can take anybody.
They what?
They said it's expanded. It's limitless.
So those are the things that would dramatically help. And the programs, especially the people sitting next to me at this table, I've worked with these programs. They're incredible programs, and the options are just not there. They need to be expanded, not just for this one ATD program,
Right.
for other community-based programs that run successful ATDs and ATIs, for us to be able to get, I mean, we don't have the authority to place someone. The
Right.
judge has to do that. And so, you know, that option has to be there, and it has to be something that the courts are willing to do.
And they should have these programs across the borough.
Correct,
To make
yes.
sure, is that what, do you know where Good Shepherd is located in what borough?
Brooklyn.
Brooklyn, and what's the other models that they have that do work? Bronx,
The other, go ahead.
and that's it?
We have a location also in Staten Island and Manhattan as well, so we keep expanding.
Yeah,
So we can serve, the population.
I can say we operate the Choices program, which is an ACS ATD in Manhattan and the Bronx, and there are other service providers who operate it in the other boroughs. But I think what you're hitting on, council member, is a real lack of investment, not
Correct.
only in the ATD and ATI infrastructure, but also at the earlier stages. And so I think when we look at what we need to do, it's not just restore the cuts
Correct.
and invest in some of the programming that's, been subject to these cuts, but it's really building out the robust services that our young people need. And our city was doing that and, was adding supports, and then has really kind of moved away from that in a way that's very harmful for our young people.
Very harmful, as we see the numbers have doubled up in how many of the young people entering these juvenile detention centers. So we got to go back and look at it, and that data should have been driving that policy, right? And I don't think they're doing that. You usually use data to drive your policy, your legislation, but I don't think they're doing that. So what are your thoughts on? You said investment, but it also have to expand the the ecosystem. So there's not enough providers, not enough, a lot of everything, right? Even the job training for young people. Are they also looking at underlying causes that's leading these young people into these spaces?
Yeah, so I can speak just in terms of programs. I'll highlight a program that we run called ACEs, which is for young people. We operate in East Harlem and the South Bronx. Young people who are at high risk of being involved in violence, victim or perpetrator, who may well be carrying guns. And it's a really effective program. It's for young people who haven't been engaged by other programs. And we get referrals from a variety of sources, and we show up at your door. It's voluntary, but we show up a lot.
Right.
We're not just like going one time and saying, hey, I heard you don't like other programs, but do you want to come to ours?
Right.
We're showing up over and over again. And so we're ultimately able to enroll young people, and actually our second highest source of referrals for the program are young people who are currently in the program referring their friends, which I think is a testament to its success. And yet, we have continually had to scramble for funding to keep the program going. We would love to expand the program to cover a wider geographic area. It currently only serves young men. We would like to have a track for young women. But we're just constantly fighting just to keep it going. And I don't think that's unique. I'm sure Bronx Connect can speak to some similar challenges that they're having. But just as Councilmember Stevens said earlier, we're always like rolling out pilots and rolling out new programs.
Correct.
And then it's like, what happens? How are we actually scaling? We have a lot of great things that work, but how are we actually scaling them to meet the needs that we're seeing? And in many cases, we're just not.
Yeah, I might add on really quickly as well. So Bronx Connect also has a program for at-risk youth. So we have a contract with some schools in the South Bronx. That's where we're located. We're on 149th. And we work with them. We have a department that works with them throughout the year, and it's called YN, Youth Empowerment Network. And so then for the summer, for SYEP, we have an internship where we provide, all these different programming for them throughout. So it keeps them off the street, but also we teach them things, and we see how beneficial that is. And also, once the great thing about these programs and these organizations is once you're involved, it's very easy for you to be connected to other opportunities. For instance, Christopher and I run a youth council, and the youth council is actually, we work with young people that are part of our programs already. So we have youth from our ATI program, ATD, and YN, and we meet them through, these summer programs or just throughout the year. And and actually get them involved in making change within their community, meeting elected officials, having all these other opportunities that they didn't previously have access to. And something we see that is successful is that we're seeing these young people continuing to come to us. We have 3 young people currently in our youth council who were in our alternative to incarceration. Their cases were closed, they've dealt with them, but they still continue to come to us because they find what we've taught them and what we have, the safe space, is so beneficial to them, you know, in their life. And now they're having these opportunities, again, that they did not have before. And so we're seeing how getting involved in one opportunity can continue to lead to more and more. So that's just really wonderful to see.
Thank you, and the preventive work is also important.
Exactly.
Thank you very much. Thank you, chairs.
Thank you. I just had one question for cases for impact. I mean, what, just for us to know, because we just ask about it all the time, and do you have any specific written communication from this administration that described a rationale, and what have you all done in between that program being fully taken off, like before the program not being able to launch? What communication have you had with DOP, with them about the possibility of bringing it back on? Like, they're just like stonewalling us, so the only way we know anything is through what you all might be able to offer us here.
Yeah, absolutely. I appreciate the question. So our termination letter, the letter terminating the contract, which we got in September of 2023, did not provide a reason or rationale for why the contract was being cut. We, of course, reached out to DOP, asked for clarification and explanation, asked them not to cut the program, and we were not able to get any information. The only thing I've heard, unfortunately, is the same as you've heard, where they keep saying that adolescent portable therapy is the same thing, even though it's very, very clearly not the same thing. We were contracted to start the program in January of 2023. It's, you know, a similar program to the program that Esperanza had previously operated. We hired staff, conducted outreach, and we were ready to take our first intakes in May of 2023.
I mean, I guess between like where we are now, like what have you, I mean, especially because it's not in this budget. So regarding this budget, what communications have happened between you, or you all have just kind of put it to bed? I just want to know if you're still advocating for it or not.
I mean, we would love to see the program restored. We have not been able to have, you know, any conversations with the DOP around why they cut it or the possibility of bringing it back.
Okay, thank you.
Just a quick question to the Bronx offenders. I know here DOP today said that they do these monthly meetings that go over these programs. I just wanted to confirm, are you guys a part of those meetings? Have you been invited? Because I'm just trying to piece together their outreach situation.
As far as I know, no, but I'll follow up with the head of our adolescent representation team and get back to you.
Amazing, thank you. That's all for this panel. Next up, we have Emily, I don't know if this is a C or a G. Emily Kling, Jeanette Bocanegra, Jose Perez, Kongji. Again, I apologize for messing up everyone's name. You may begin whenever the spirit hits you.
Can start. Chair Stevens, Chair Nurse, and members of the committee, thank you for holding this important oversight committee. I'm Emily Klinger, and an attorney with the Special Litigation and Law Reform Unit at the Legal Aid Society Juvenile Rights Practice. I do refer you to our fuller written testimony, but I will highlight some of the points this morning. I strongly urge the City Council to ensure adequate and effective services are available to all young people involved in the criminal and juvenile legal systems. We have serious concerns about this city's significant cuts to alternatives to incarceration programs, as noted in the decline in probation's adjustments and in community monitoring known as ICM. As a specific aside, we also, as mentioned by BDS, we have also been told that ICM has no capacities in a number of boroughs as early as this morning while testimony was going on. The city's massive investment in building a nearly 50 additional bed secure detention facility annexed to Horizon is also a serious concern we have and cuts against decarceration efforts. We can and must reduce the number of youth in detention. Social science has shown that it will make a commitment to communities safer and lead to better outcomes for youth. First, we must invest on the front end before a young person ever becomes involved with law enforcement or the legal system. This should include increased in-school cure violence programs, including the Legal Aid Society's Community Justice Unit, as mentioned, that had recently experienced large cuts, have been shown to be effective at deterring even the most serious crimes and offenses. These should be expanded, not cut. Second, we must provide a robust array of alternatives to detention and incarceration programming. I can tell you from personal experience recently representing young people in both criminal and family court settings that it takes great efforts for defenders to identify suitable programs that address our clients' needs. Even after a program has been identified, we're often faced with the reality that this program is no longer funded or does not have capacity. Judges, prosecutors, and defenders regularly call for more programming and are looking for off-ramps from the juvenile legal system, even in the context of the youth part. These issues are especially dire in the youth part because adolescent offenders and juvenile offenders account for the majority of youth in secure detention. The lack of alternatives is directly responsible for this increase in secure detention that was spoken about today. Adolescent offenders and juvenile offenders are frequently ineligible for criminal court programming due to age restrictions and for family court services due to funding structures or charge-related restrictions. New York City must conduct regular assessments of the needs for alternative to detentions and alternative to incarceration programming, and then the need must be then met. Funding increasing secure beds at a cost of millions of dollars is not the right path forward. And to address some questions that were posed in the last panel, as I had mentioned, we had recently spoken to our defenders in boroughs. We have been told that ICM is at capacity. In addition, just to clarify the question about probation's discretion, the Family Court Act is the ruling statute. They had mentioned there was black letter law there. However, our interpretation of that isn't quite clear. It's quite discretionary. There are a number of specific crimes that are listed in the Family Court Act. However, it does say
10 seconds.
That the probation department can request from the court specific acceptance to divert that young person away from filing. I would also note that there is a long list of discretionary qualifications that probation can use to then, outside of those enumerated offenses, can then use to justify bringing it to the law department. So it is not quite as clear once you have the opportunity to take a look at the statute.
Thank you. She could, Councilmember Williams, you can follow up with the questions.
Yes,
please.
thank you so much, and thank you for your attention to these issues.
Thank you.
I get nervous every time I come out. My name is Janet Bocanegra. I wear two hats. I am a national leader of Justice for Families, an organization that works with directly impacted families in the juvenile justice system. I'm also a mother of 6, and in 2010, my youngest introduced me to the system, and I couldn't understand, I couldn't wrap my head around. But what I do know is that there have been programs that have helped our young people. We've shut down facilities that have traumatized and dehumanized our young people. And due to those inhumane treatments, we're dealing with chaos in our communities and trying to fix all the issues that these institutions have been part of. I can't understand that we had 3 large agencies here that we trust in taking care of our children, but what they have done has disrupted their development. I'm not sure why the new administration decided to close and defund many of the programs that have been working, but I also feel that we need the school system here. We need the We need to address the school-to-prison pipeline and not expect probation to be the solution to all the issues that our communities face. Investing in developing a new housing unit or prison, whatever we want to call it, is not productive to the community that we're serving. In 2010, I got involved in a research project, which was a national project, which allowed us to even partner with the Department of Probation. And part of some of the programs that they created was a parent support program. Though parents are not included in decision makings and parents are stigmatized in when a young person is navigating the juvenile justice system, but I strongly encourage you to look at some of the successes that has happened during these Alternative to Incarceration program. The community can be a resource, right? Defunding some of these programs is not the solution. I am still working on putting together the pieces of broken young people coming back into our communities. Yesterday and on Monday, I sat on a 5-hour training to learn about PREA, the Prison Rape Elimination Act, where our young people are being dehumanized, groomed, and inappropriately touched. And these are the issues that we're facing. Our young people are also coming back less educated. And when we talk about discretionary decisions, and I'm going to end it with this, during COVID, every leader was able to make a discretionary decision without looking at a policy, because everyone was being fair about all the injustice throughout all the systems. So we're looking at DYCD, right? They need to do a better job. They use the word violation. Or do they work in collaboration with systems, or are they really developing thriving young people? ACS, who we trusted in making sure that young people and families are connected, what they've done is disrupted and torn families apart. And probation, right, has done a great job, and the family court in graduating our young people to the adult side of the system.
Thank you.
Good afternoon. My name is Kyung Ji Ri. I'm with an organization called the Center for New Leadership and New Leadership on Human Justice and Healing. And I know I have 2 minutes, so I'm going to try to cut to the chase. I am here to tell you a 22-year-old story and to get to some solutions and where it really lies. And the real deal has to be done in full depth and in the follow-up. But I want to put out some big thoughts. In your hand is a list of questions that we prepared as we look at some of the proposed expansion plans by ACS and the talking points that are coming out. I've been in the criminal justice reform world from all aspects of that world, from service to advocacy to legislative writing to campaign leadership. 22 years ago, we stopped the city of New York from expanding Horizon and Crossroads by 100 jail cells each. It was done by Justice for Youth Coalition that was youth-led. We didn't even come out to the public until like a year after we found out about it, because we were doing that internal work. We stopped it. It was $65 million then, 100 jail cells. Right now, it's $340 million for 48 jail cells with other improvements. If I were to do a quick math there, that's $340 million divided by 48 jail cells. That's about $7 million. Or no, I think I divided by 267, by the jail cells. It's $7 million per jail cell. So when you look at the investment that we're willing to make on the juvenile justice side, the criminal justice side, and you compare it to the education cost, back then, 22 years ago, it was $9,300 that we spent per pupil, which we know is not enough. Right now is about $30,000, right? And I also don't want to just go off saying alternative to incarceration is cheaper. Alternative to incarceration programs do a lot with so little. It needs to be resourced, and if we're going to find the solutions, it's not in ACS or probation. The solutions that we do need to get at for the legalistic stuff is for access. But the real solution is going to lie in the resourcing and how it's resourced. We didn't even get to the questions around the program limitations, the challenges. If programs had more resources and had the flexibility of spending, There's so much being done, and the last thing that I would say is this. My 10-year-old asked me what I was doing this morning because I said, Mommy has to hurry, get to city council oversight. And she asked me what the oversight is about. She's part of everything that we do. Everything that we do, all our staff members bring all our children because we're building a village. It's not about reducing recidivism. It's about building community generational wealth and health in the $1 million blocks that are targeted by policing and state violence. So if we do that lens, she said, but if they build 48 new jail cells, they will have to fill them because they can't leave them empty. So then they will look for ways to lock up kids. A 10-year-old got this notion. So it's about priorities and willpower, and the solutions are there, and we will follow up as such. Thank you.
Thank you for that. Good afternoon, and thank you, Chair Stevens and Chair Nurse, for holding this important hearing. My name is Jose Perez. I am the project manager of Youth and Power at the Children's Defense Fund, New York. I come to this work as a lived expert in the child welfare system and also juvenile detention system and also the adult criminal justice system. And also as a former service provider for cases. Today at the Children's Defense Fund, I work with impacted young people to help shape the policies that affect their lives while transitioning out of the foster care system. I take pride in centering the voices of young people as we live by the motto, no policy about us without us. As the city plans to expand programming space and increase beds in secure detention, it is critical to focus on decarceration. And it's by the testimony that I heard earlier, it's obvious that our leaders have no idea what decarceration means. We need to support as many young people as possible in the community, and that will require coordination by all the city agencies, and that means ACS, DYCD, MOCJ, and DOP. These departments' heads need to be held more accountable for their actions. It is a gross miscarriage of public service when a leader in any department is not a subject matter expert in the field they were hired to work in. I work with young people every day. I manage the direct cash transfer for 100 emerging adults out of the foster care system in New York. I am led by their power and love, and I am saddened to hear that our people in powerful positions are not listening to them. The conversations I am having with young people every day on the ground, young people on our work are clear about what they need. They need jobs and mentoring, support from healing from trauma. We have not said anything about trauma in this room since I've been sitting here. We need a more trauma-informed care approach. They need more stable housing and community connections. Young people in detention lose all these things when they are on the inside. So the first of many steps toward decarceration is urgent. So in the budget that you are negotiating right now, we must restore the cuts to alternative to detention and youth mentoring programs at the Department of Probation. We stand ready to partner with you. Thank you.
Thank you. I just had a follow-up question from some of the testimony because I know you said that as of early as today, folks were told that ICM programs were at capacity. Do you have the boroughs? Because as you heard today, they said that they were ready to go and it's citywide now. And so I'm just seeing, was there specific boroughs or was this a trend that they are seeing just citywide as well?
Yes, I believe in Staten Island.
I'm sorry.
Apologies. Yes, I heard directly from Staten Island that from Staten Island practitioners today, just to clear the record, not necessarily from the court liaison today, but Staten Island practitioners today, that in the past week it has been told that ICM was at capacity. I believe, and I would need to check my notes, but I believe within the last week, maybe as early as last Friday, ICM in the Bronx was at capacity. And at least within the last month, ICM in Brooklyn was at capacity. That could also be more frequent than the last month, but that was the last time I spoke to our practitioner.
No, I just wanted to make sure we had it on the record because it was said today that it was citywide and there was no limits to them being able to set young people. So I just wanted to make sure we had that clarified.
If I could just clarify one more thing for the record. The Legal Aid Society is invited to these monthly meetings with
you guys are invited. Nice.
With the Department of Probation. However, those are most specifically focusing on child welfare issues, and juvenile justice issues are rarely discussed. I checked in with a number of our practitioners who attend those meetings, and that was clarified to us. So I just want to make sure the record is clear on that note as well.
So there is a meeting, but it's not necessarily about the programs that we were talking about today and the low capacity and folks not. Okay,
That's my understanding.
Thank you. I'm sure. Councilmember Joseph?
Thank you. Earlier you mentioned, how long must a young person wait to be placed in a program? What's the wait time?
For what type of program, apologies?
Any of the decarceration programs, how long is the wait time? You say sometime you call and they're at capacity. When they say they're at capacity, what are the next steps?
At that point, we have a young person who's facing potentially remand or a detention order. And so we're constantly looking at that program or alternative programs. I would say in my experience as a public defender, when that happens, we look to the community and we try to find colloquially alternatives to the alternatives.
Got it.
And we're looking at community therapy, we're looking at community supports, community cure violence programs that aren't run by the city and the state. And a lot of the times our judges are open to those options, right? As long as they can speak to providers and guarantee that what they're hoping for as far as like some kind of monitoring and support is in place, they'll give them a chance. And a lot of times our clients are succeeding in those. So once we're told they're at capacity, we have to look elsewhere because it's dire. Our kids are then gonna be in a detention
Time is
center.
not on our young people's side because we
Exactly.
don't want them out there because they get reintroduced into the criminal justice system. How many students, how many children in foster care do you service?
I service I service 100 former foster care youth who just recently were part of a pilot receiving $1,000 per month in a direct cash transfer pilot program. And I also manage 14 youth action organizers and researchers who all have direct and indirect experience in the child welfare system and juvenile justice systems as well.
What age group?
Age group anywhere between 18 to 22.
Okay. Thank you.
Councilmembers, did you have follow-up about the statute stuff that she was clarifying before? Okay, all right, no problem. Thank you. That sums it up. And just to say, you know, in my opening testimony, I clearly stated that we have to come together to really create a decarceration plan for young people, and we can't wait because no one's going to do it. And so I'm very serious about this. I mean, a number of providers, we've already been talking about this, but this is something that for me is a top priority. And so definitely look forward to working with anyone and who's willing and open to really start working on a campaign to make this happen. So I'm sure I will be in touch with folks. So thank you.
Right.
Thank you.
Thank you.
We might need another chair because I don't know if there's enough chairs. Rashad Brown, Darren Mack, Crystal Ramona Smith, Chaplain Dr. Victoria A. Phillips, Jason Alari, Aaliyah, Gilroy Nickens,
My name is Rashawn Brown, Director of Community Wellness for We Build the Block. For the last 6 years, I've worked with hundreds of justice-impacted youth between the ages of 14 and 24, spearheading programs funded by MOCJ and DYCD. Many of these youths were justice-impacted before I met them, but once I met them, I built a relationship with not only them, but their entire family and social group. You see, they didn't trust me overnight, but through persistence, transparency, and consistency on my part, they came to love me as if I was a family member. The foundation to success is love. Once they understood I loved them too, their minds were open to the possibility of life. Leveraging Eddie Ellis's model on non-traditional approach to social and reformative justice, I've helped countless young people go from alone and desperate to high school graduates with beautiful plans for their future. No matter my role or agency, it was the connectivity of love and understanding with tangible support and resources that can make all the difference in a young person's life. Unfortunately, my work brings me inside of places like Crossroads and Horizons and leaves me to deal with the crisis created upon re-entry from these child jails. In all my interactions with residents of the child jail, I have never once heard a youth talk about the exceptional schooling or social programming. And one must ask, why are we so invested in a fictional social capital investment in a carceral setting and not in our community? Eddie Ellis once said, prisons represent the failures of society. This $340 million proposal is not an investment in building the social capital on these kids, but an investment in continued rampant structural violence in marginalized community. While serving 17 years in New York State prisons, I learned how to make ghost guns and cut drugs with fentanyl. It wasn't until I was enrolled in Bard College was I able to see the future was not in selling drugs or making guns. I deserve better and my community deserves better, and better is possible. That is why I made my commitment to helping youth see that education is an investment in self. This 48-bed expansion is definitive proof that you have given up on yourselves and your ability to fulfill your job responsibilities. People have made a commitment to making communities better, stronger, and safer. Instead, you have all sacrificed future generations and communities. And with that, thank you.
Peace and blessings, everyone. I'm Chaplain Dr. Victoria Phillips. Everyone calls me Dr. V. And I actually work at the Mental Health Project at Urban Justice Center. Been there almost a decade, and I'm the CEO and founder of Visionary V Ministries. And I sit on several boards and task force, so I won't name them all. But I want to highlight, years ago, I'm actually just going to say a few points. I know I don't have much time. So years ago, I actually used to sit on the New York City Department of Corrections Adolescent and Young Adult Advisory Board with DC Nancy Ginsburg, who was here earlier speaking for ACS. And I want to highlight that because back then, adolescents were sleeping in class as well because of issues that the city was not properly addressing. So this is nothing that's new. And I also want to highlight, even on the island, we spent millions of dollars as a city to renovate GMDC for the adolescents and young adults before they was moved and after they was moved off the island, and the building was then handed over to officers. So all of that money that could have assisted with public safety on the island and all of that changing someone's life, was taken away and given to officers. And I also want to address buzzwords, legal and repeat offenders. These words actually land differently in different zip codes. And I want to say that because diversion is key. Today, the city said 801 cases are referred for diversion, but how many of them actually end up serving because of the diversion and the pleas that they taken? Because when we talk about rearrest, what does that look like? Because I know in Brooklyn, a rearrest could be walking down the street and the officer target you. My own son was targeted coming home from football practice, and it took 9.5 hours to get him out of the precinct with the other child that he was arrested with. And I say that because if I didn't know my rights, and as a parent, my child would be through the system. Can I just get 30 more seconds, please? And I just want to say how important it is not for us to just talk about diversion and decarceration, but education for the parents that are responsible for these kids, because educating the parents is how we keep our kids out of the legal criminal system, or don't give up all rights. Because even in probation officers will try to get parents to sign all types of forms, giving access to things that they really don't need, even access to school records, and judges use school records. And I know as a parent, I actually fought in probation, and the officer called his supervisor trying to scare me on every way to sign all these forms. And even lawyer that I brought was saying, Dr. V, just sign the forms, and I would not sign them. And I say that because my son walked away. I said we're going to go to trial. Charges were dropped. The judge ordered that all prints and mug shots be destroyed by the precinct and the state. And I say that because the other child that I helped, his mother was scared, signed the forms. And I say this because 10 days before that boy was supposed to get, 10 days before that boy was supposed to get off, he was rearrested in the community. And right now he's serving 5 years based off a paper that he signed because his parents were scared and did not understand their rights. So if we're going to take care of our youth, we have to start properly by resourcing the community.
Thank you.
Here, Derek.
Good afternoon. Thank you, Chair Stevens and committee members. My name is Darren Mack. I'm a co-director of Freedom Agenda, which is an organization dedicated to organizing directly impacted people and communities to achieve decarceration and system transformation. I'm also a survivor of Rikers, where I was incarcerated as a teenager, and a member of the Commission of Community Reinvestment and the closure of Rikers Island, established by Local Law 193. This commission is charged with ensuring significant reinvestment recommendations are made in communities disparately and historically impacted by mass incarceration. I co-chair the Youth Subcommittee, and just before Mayor Adams took office, we released our first set of recommendations outlining dozens of recommendations for upstream community investments. 7 of them focus specifically on youth. I hope we have seen the mayor jump on the opportunity to turn his campaign promises into action and make these investments, closing the pipelines that feed Rikers. Instead, he has ignored the law that requires him to convene our commission quarterly and host public meetings. Meanwhile, the number of admissions to youth jails has skyrocketed, and there are over 1,200 young people 25 and under at Rikers today. The mayor has used these circumstances created by his failed policies to propose an expansion on the Horizon Youth Detention Center and to stall on closing Rikers. We know that locking up more youth will not increase safety. Simply removing a young person from the community does not solve the underlying conflicts and cycles of aggression, protection, and retaliation that drive violence. In fact, conflicts in the streets often carry into jail and prison, and in a horrible cycle, conflicts in jails and prisons carry back into the communities we aim to keep safe. New York City has successful programs that already work to reduce incarceration and improve both wellness and safety for youth. But Mayor Adams has repeatedly cut their budgets while maintaining the most bloated jail system budget in the country. I want to thank you, the City Council, for calling on Mayor to restore funding cuts to DYCD and other services that support our youth. Even district attorneys Darcel Clark in the Bronx and Albert Bragg in Manhattan are telling us that long overdue community investment is what will increase safety, not more incarceration. If the mayor won't agree to those essential changes in the budget, we urge the City Council to use every power you have, including passing a budget amendment to assure a just budget for our city. Thank you.
Thank you. Hello, my name is Crystal Romero Smith, and in community, I'm better known as Lily. I'm a program coordinator at Community Connections for Youth, CCFY, in the South Bronx. CCFY first met when I was 15 years old, facing probation and potentially severe consequences. The love, support, and advocacy I received through the South Bronx Community Connections program changed my trajectory of my life. The goal of SBCC was to connect me to my community, and through that connection, to myself. My world opened up, and I was provided with resources that set me on the right path. I led my leaders, guided them through the criminal legal system, and shared valuable lessons and best practices with adults working with youth just like me. I became more than a young person who didn't reciprocate. I was activated. My life, my thinking, my self-belief, and my hope were all positively transformed by the relationships I built, thanks to the community supports and system funding. Now, as a staff member of the organization that once advocated for me, I strive to provide the same foundational support to others. In my role, I see firsthand the transformative power of community support for young people. And I recall how our partnership with the Department of Probation supported credible messenger roles and leadership, showing young people their probation officers as allies. These positive interactions fostered trust and transformed youth perspectives. Unfortunately, recent city administrative decisions have taken major steps backwards, reinforcing an us versus them attitude. These actions have removed crucial opportunities from young people, making quality mentoring and employment opportunities even less accessible for under-resourced communities. How does these stabilizing communities lead to greater safety and hope? My question is, what are you doing to truly support our youth? Bare minimum opportunities would never have reached me, and by reaching me, you now reach many others. Alternative to Incarceration's work is proven, yet we still wait for evidence of the positive effects of incarceration. Incarceration grooms young people against its own stated intent. And today I stand with a young person impacted by the juvenile justice system. Despite my justice involvement, I'm being seen as a problem to be solved. I was treated as an asset to the community, and I became just that. I asked you to change course and end the poor family and community actions. Our mission remains no kids in cages, and we need to invest in our youth and not detain them. By supporting community-based programs, we can create restorative spaces for young people to grow, explore, heal, and learn. Thank you.
Good afternoon. My name is Aaliyah Guillory-Nickens. Thank y'all for having us. I currently work as the campaign organizer at Youth Represent, which is a nonprofit organization that provides free legal services and mental health support to young people under the age of 26. Additionally, we work on policy and legislation that will help youth in the system while also supporting young people who have or haven't been system impacted to become civically engaged and training them to become advocates in their community. Outside of Youth Represent, I am a community organizer out of Harlem that began this work after getting my last case dismissed at 16 years old and introduced to programs that helped me get to the position I'm in right now. I'm here today to voice my concerns on the city and ACS's plan that do not include youth decarceration, but do unfortunately include adding more beds to detention centers, cutting funding to valuable programs, and other efforts that will do more harm to young people and communities than good. The city, ACS, and probation are moving in the wrong direction when it comes to youth decarceration, and I'm urging you all today to push them to move in the right one. The Department of Probation has significantly cut funding to alternative programs that include mentoring, credible messenger programs, and programs in our communities that are actually keeping young people safe and productive. I've seen it firsthand, and I'm a product of those same programs. ACS received funds that were intended to improve areas of detention such as visitation spaces, services, and programs. Instead, with these funds, they are adding 48 beds with no clear explanation as to if these additional beds are needed. It's completely backwards and senseless to prepare to incarcerate more young people rather than prevent the incarceration of more young people and actually properly care for the young people already incarcerated that are being assaulted, sexually abused, mentally abused, and forced to fight each other and other things in those detention centers. New York City has 250 lawsuits already, and there's probably more coming, with claims of sexual abuse in juvenile detention centers. That means the priority should not be adding more beds to funnel more young people into those same detention centers or cutting funding to programs that give young people what they need to not come into contact with the system anymore. It seems as if we are still trying to use the same punitive methods in our legal system that we've been using for decades, and we've been seeing it not working. Doing the same thing and getting the same results is an inch away from insanity. Incarceration is and will always be harmful to all parties involved. That includes the people that are being incarcerated, families, and communities. I'm almost done. And locking up our youth at crazy rates will not make the crime drop, that's clear. It is urgent that we invest in prevention and diversion to decrease our secure detention population. The $340 million that ACS plans to invest into secure detention centers needs to be reallocated into community-based programs that prevent youth from entering the system and into the youth part of the Supreme Court that is severely lacking the resources needed to effectively divert youth from incarceration. There are amazing programs really doing, I'm almost done, I'm just gonna say one more point.
Thank you.
Okay,
Thank you.
Thank you.
Good afternoon, Chair Stevens and members of the NYC Council Committee on Children, Youth, and Criminal Justice. And thank you for the opportunity to testify here this afternoon on coordinating NYC's youth decarceration efforts. My name is Jason Aline, and I am the Chief Program Officer at Exalt, an organization effectively elevating expectations for youth in the justice system since 2006. A week ago, our city celebrated Juneteenth, a federal holiday reminding us that slavery did not end overnight. At Exalt, our ethos is rooted in the knowledge that mass incarceration stems from slavery, and that in order to end mass incarceration, we must deeply invest in our young people. At Exalt, we empower our youth to see a future filled with hope, and we provide the roadmap to get there. Exalt serves criminal justice impacted youth between the ages of 15 to 19, many of whom are chronically disengaged from their schools, overaged and undercredited, and reading at a 4th grade level. Our powerful model, comprised of tangible skill development classes, paid internships, and robust alumni network, equips our youth with the tools and experiences necessary to not only avoid recidivating, but truly experience the best that life has to offer, because that is what our young people deserve. Our participants have 5 dedicated staff members working with them throughout their cycle: a program coordinator, teacher, educational advocate, internship liaison, and alumni liaison. During the first 6 weeks, Exalt youth are immersed in our pre-internship training. This includes our culturally competent, responsive, and academically tested curriculum that rejuvenates their love of learning through content that is connected to their lived experiences and delivered in an engaging way. Upon completion of the pre-internship phase, our participants are placed in an 8-week paid internship in high-demand fields throughout New York City, including a vast array of nonprofit, business, and government entities. Exalt pays program participants $18 an hour and our alumni $20 an hour. With our youth, while our youth are actively engaged in the education and employment components of our core program, Exalt's court advocacy team provides support and helps navigate the complex landscape of the criminal justice system to those with open cases. Our advocates build deep partnerships with major stakeholders that comprise the system, including district attorneys, probation, and the judiciary. Utilizing the cross-sector approach, Exalt has achieved remarkable results with young people that in many ways society at large has not. We are proud to say that 70% of the young people that come to us with open court cases have their sentences reduced or dismissed, 98% are on track to graduate by age 20, and even 2 years after graduating from our program, 95% do not recidivate. As this council and the administration work together on youth decarceration efforts, our city's youth need you to prioritize funding to organizations like Exalt, whose proven model yields real results and truly transforms the lives of our young people. Thank you for your leadership and dedication to addressing how the criminal justice system impacts young New Yorkers.
Sorry, respectfully, I just wanted to finish a little bit. I feel like other people, they went over time, but they got their extra couple of
No, I
seconds.
actually went
only
back
have
and
some
asked
sentences
questions,
left.
so thank you.
Okay, I just wanted to shout out some organizations that are doing great work, like Youth Justice Network and Arches. Respectfully, though, I was just trying to do that because I was cut off, so.
Sean Corey.
Good morning. How you doing? My name is Sean, and I'm here to read a oral testimony. So, hello, my name is Sean Coley, and I'm a youth participant of Neighbors in Action, SOS Save Our Streets. The reason why I wanted to join SOS is because I wanted to change my mindset and help the communities around us. I wanted to do better for myself and show others that we can all change together as a group and share ideas to better each other as one. Programs like SOS have helped youth like me stay out of trouble and switch course. They mentor us, they provide us with job opportunities, and show us how to get back. And one thing that I've learned from being in this program is that we can team up to help people feel safe wherever they go and set some plans to make the streets feel safer. A way I help make the streets feel safe now is by designing and distributing flyers to bring awareness to stop gun violence in my community, as well as encourage people to come to our events. By being a part of this work, I now want to keep giving back and start my own program to help fund trips for the kids who are willing to participate and stay out of trouble. Jails are not the answer for programs like SOS is. Thank you.
Thank you. Christine, I think Lee. And thank you, young man, for testifying. I really appreciate your testimony today.
Hi, good afternoon, everybody.
Good afternoon.
My name is Christian Lee. I'll be representing Bronx Community Justice Center. I would like to talk about like things that going on and like in the neighborhood and everything. I come here to say that Bronx Community Justice Center is a way of me giving back to like everything that has been going on and everything that's been going on in the streets, and I'm here to represent them because I feel like they gave back to me, so I want to do the same to everybody else. They're very positive. They give job opportunities, many different things, as in getting back on track and pushing you and being enthusiastic. The program is very amazing, and me as in being like going into like incarceration and things, they helped me and provided with many different opportunities of me thinking of like a way of getting out of the streets, like as in positive, because the mindset of them is like, okay, everybody is welcome, everybody has a future, everybody can do something, why not do it? And embrace yourself and do as many things as you can. And I feel like them giving back is just a way and an opportunity of like just saying like open arms, like everything is here. You don't have to worry about anything. And they're just like open arms, very good like citation of being there for you. Oh, yeah.
You're doing great. Thank you. You're
sorry,
so
I'm
stressed
hot.
out. It is very hot in here. No, we appreciate your testimony.
Thank you.
And someone please it's water right there, just some water. Thank you. Now we return to remote testimony on Zoom. Our first and only witness will be Daniel Garad. What is that, Danielle? You may begin your testimony once you're unmuted and the sergeant will start the clock.
You may begin.
Thank you, Chair Stevens and all the committee members. My name's Danielle Gerard. I'm a senior staff attorney at Children's Rights. We are a national organization that advocates on behalf of youth in state systems here in the city on behalf of young adults on Rikers. We recently submitted a public comment to the Board of Correction regarding the law banning solitary confinement and have also uploaded it to the site for this hearing. It includes a great deal of research regarding youth brain development and the criminalization of mental health. We would like to highlight one of the points we make and some of the accompanying data. Mental health is integral to overall health and well-being, especially for adolescents, shaping their development and influencing their responses to stress and social interactions and supporting healthy decision-making. The lack of investment in community mental health services results in police and agents of other punitive systems responding to children and youth experiencing psychiatric distress rather than trained behavioral health personnel. As a result, youth with mental health conditions are more likely to be arrested and incarcerated than those without mental health conditions. Nationwide data show that 70% of incarcerated young people present with a diagnosed mental health condition, compared to 18 to 22% of all children. Once involved in the child welfare or juvenile legal systems, youth who are Black or Brown, LGBTQ, and or living with a disability disproportionately face the most profound mental health challenges. Young people themselves describe the child welfare and juvenile legal systems as traumatic, and youth who experience these systems often have poor mental health outcomes. The criminalization of mental health is a direct result is a direct result of the lack of investment in community mental health services. We urge the council to stand firm in supporting our communities, especially when it comes to the health and well-being of all our city's children, incarcerated or not. Thank you for this opportunity to testify.
I would like to say thank you to everyone who took the time out to be here with us at this hearing today. Also, special thanks to Chair Nurse and our committee staff who worked really hard to prepare. But as we all have concluded, there are still a lot of unanswered questions. And that means for us, we need to continue to work. And like I said at the start of this in my opening statement, we really have to come together to create a decarceration plan because the numbers of young people in incarceration currently are unacceptable and we cannot allow it to continue to grow. So with that, I would like to close this hearing. Thank you.